Yes, mention the applications in order for doings. Without
Milord,
the other matters, please mention. Yes.
yes, Milord.
Yes, item number 39 of Milord list. Milord list. Matter Milord, perhaps Milord will
Four
consider
player लिखी है
orders
circuit
passed
bench.
shifting the
ऊपर में
admissibility,
circuit bench of four players.
Tell us in a nutshell. We won't go through the orders.
Matter was agreed for one of the parties.
Oh, 39.
Circuit bench लिखा हुआ है यहाँ पे.
39. It won't be called on today. If it is called on, just remind. And otherwise, it will appear as to be mentioned on Tuesday. It to be mentioned on Tuesday. Yes.
Lordship, there has been a decree passed on 19th of February. Thereafter, we had filed the second appeal on 28th of March. The decree is the decree will be ripe for execution in this 9th May.
Has the second appeal been admitted?
It has not been admitted.
It's an order for 21 matter admission.
Pure from our end.
Even without mentioning, you could have handed over. We are asking for admission hearing and applications by default. Yes. Yes.
But matter appearing item number 100 and 101. There's some urgency. This pertains to us. It's an assigned matter, pertains to a small office space in Nico House, where somebody is trying to make an unauthorized construction. I need to get into the property. There's an eviction suit that was filed. It got dismissed on the ground that there was somebody else in. He had handed
There are
over.
more urgent matters, Mr. Banerjee, where people are they will be evicted. The other way around. So those are more urgent. No.
Any day, my lord,
No,
before
Mr.
the
Banerjee, no. Before the vacation, forget.
after. It's an assigned matter, my
No,
lord.
no upgradation.
No, not upgrade. After the vacation, lordship will fix it on any day.
This was a matter where
That's an upgradation. That will be an upgradation.
If on different list,
No,
then
You cannot jump the queue. Yes.
I have mentioned one second level for admission. Mr.
Admission,
Raithod
yes.
is online.
Yes, we are taking.
Milord, this matter, Milord, pertains to Milord circuit bench of four player. Milord, yesterday, Milord, I had mentioned the matter before the Honorable Chief Justice, Milord. Considering the urgency, Milord, I was allowed to file appeal, Milord, with a server copy. And Milord, I also prayed for Milord to move injunction application, Milord.
It's a first appeal.
Yes, Milord. First appeal, Milord. Order 7, Rule 11, Milord.
Circuit bench is not functioning now.
Yes, there is not functioning.
When will it start? Next week.
June. And my lord, there is an immediate threat of disposition, my lord, by the
Hand over it to
administration.
Jalpaiguri matter will agree.
Yes.
My lord, may I be pleased to
Great.
mention a matter? My lord, this is an appeal arising out of a suit for specific performance
What
and
are you
injunction
mentioning it for? Inclusion as?
for inclusion in the daily list
For what? Admission hearing or?
for admission of the appeal.
Yes.
Much obliged.
What is the matter?
This is the first appeal matter.
First appeal hearing?
Yes, no, my lord, this is admission. This is
First appeal is not required to be admitted formally.
this is for hearing.
No, sorry. Yes.
Order 41 I had mentioned yesterday, Lord, your Lordship's officer told me, my Lord, that it probably does not need to be mentioned. It will come automatically in the list.
Order 41s do come, but even then, if you have mentioned, it will come.
Lord, may I just give the slip?
Why are you
my lord?
mentioning again?
Because
and
the
again?
department told me, my Lord, that I have to give a slip. I have to
If
mention
you
the
have
matter.
mentioned, we'll send a requisition.
I mentioned it yesterday, but since your Lordship had,
Whenever the file comes, we'll give it in the list.
may I just give your Lordship's officer the
Why
list?
repeat? Why repeat it? No.
Yesterday it was not taken, my Lord.
Anyway, call on the list.
Sorry, my Lord.
Accordingly, FAT number 516 of 2019 and FAT 3 of 2019 are allowed in part, thereby setting aside the judgment and impunity dated such and such, and remanding the matter to the referral court for adjudication on the points given herein below. Roman 1, 2, 3, 4. The compensation of the acquired land of the claimant is fixed at rupees 5,52,544 per quota. It's a bit complicated. We have given our reasons. We have taken that value of 6 lakh 2, which was the highest exemplar, and we have deducted this structural cost not as per your, but we have taken the. They gave two values after deduction. We calculated after deduction, if it is taken from their own valuations of those your valuations, then two values are coming of the structures. One is around 28,000 and another is 49,000 something. Your valuation is 45. We did not take yours or their lowest. We took their highest, deducted 49, and this is the amount. 5,52,544 per quota. The solicium of 100% of compensation amount as stipulated in section 30 shall be calculated by the referral court on the basis of the above compensation and awarded to the claimant. The referral court shall also award interest at the rate of 12% per annum as per 33. The referral court shall grant an opportunity to both sides to adduce evidence if they so choose on the limited question of the date of possession and as to whether the parameters of section 72 and section 80 of the 2013 Act, it should be, sorry. 2013 Act are satisfied in the present case, in the event the parties or either of them choose not to adduce evidence or the evidence is not satisfactory, it will be open to the referral court to look into the relevant materials and or call for the necessary records from the appropriate authorities for ascertaining the relevant factual parameters. And upon such exercise, if it is found that the claimant is otherwise entitled to the interest contemplated in section 72 and or section 80 of the 2013 Act, the referral court shall award such interest to the claimant in terms of the said section. For the above considerations, appropriate multiplier in terms of section 26(2) shall be applied by the referral court. It is expected that the court will do the entire exercise within 8 months from the date of communication of the judgment order. Interim applications are disposed of accordingly because we have not entertained either of your order for notice. No rest to cause urgency.
For us, 4,50,000 million, the sum was deposited. We have withdrawn 30 lakh of the sum. The rest is lying. So it is not within 550. It is 4,50,000 at the rate awarded.
We'll pass up আচ্ছা একটা লেটার করে একটা অর্ডার করে দিন after the above judgment is delivered, it is pointed out by learned counsel appearing for the claimant that an amount of rupees 45 lakh, what was deposited?
1 crore 3 lakhs was deposited, out of which 30 lakhs have been withdrawn by 73 by order dated 22nd of February 2020.
Submits that an amount of rupees 1 crore
7 lakh 22,989. 1 crore 7 lakh 26,989.
was deposited. The amount. No, Mr. Banerjee, be clear on that.
The decretal amount. This is the decretal amount.
Achha, very well. It is it is submitted by learned counsel for the claimant that the decretal amount was deposited with the learned registrar general of this court, out of which an amount of rupees 30 lakh has already been withdrawn by the claimant. What do you want to?
The rest of the amount would be lesser than 550 because the lordship has 5,50,000 and this was calculated 4,50,000 only. So anyway we shall get this amount. We're entitled to this.
Does it come within that?
It has to be because it was calculated at 4,50,000.
Oh, right. The balance amount, along with interest, shall be disbursed in favor of the claimant as and when so approached by the claimant, by the learned registrar general after deduction of statutory charges. এটা লেটার অর্ডার করে দেবেন। Thank you.
Time limit not for the
that register approach the registration.
development.
My appeal, it was there was a direction of administrative notice to be issued initially on 22nd August 2022
On the respondent?
on the sole respondent, the matrimonial appeal. Now, my lord, that was inconclusive. On the last order, if my lord kindly sees, there was a direction to submit a report. Since there was no report with regard to the notice of appeal and the administrative notice.
What is the order date? Our order?
It was order dated 19th of September 2024, my lord. Passed by Justice Prasad.
19th of September অর্ডারটা কোথায়? সাজানো নেই অর্ডার? 24 অর্ডার তো লাস্টে।
আচ্ছা মধুরেশ প্রসাদ
এটা সাজিয়ে দিন অর্ডারগুলো। অর্ডারগুলো ঠিক
19th September 2024.
একটা ভাবে রাখবেন মানে পরপর। Justice Prasad, let the department supply the requisite information, submit a report in this regard.
Probably a report has come, but it's
Where is the report? Report একটু দেখে নিন।
it's inconclusive probably.
এই
still.
19 সেপ্টেম্বরের পরে রিপোর্ট আছে। আমরা দিকটা দেখছি, আপনি দিকটা দেখুন।
15/1/25
কত তারিখ? 15/1
notice of appeal upon the sole respondent has already
আপনার হাতে যখন আসবে একটু সাজিয়ে নেবেন। আপনি আপনার লোককে বলবেন সাজিয়ে দিন। আবার গেঁথে দেবেন, তাহলে উড়ে যাবে।
the sole respondent by letter, but till date no service return has yet been received.
Service return is not yet received.
My lord, the matrimonial appeal against Otherwise, ready for hearing. Paper books have been
So should we
prepared. my lord.
direct you to serve again administrative?
We
total
have
requisite-
served. My
No,
lord,
no, service report has not yet arrived.
no, my lord, with regard to that, I have a submission. My lord, kindly, my lord, may I just point out one thing? There's an order passed by the Honorable Division Bench on 29th of August 2022.
What does it say?
Oh, it says, my lord, in Can 2, the report filed by the department, there was shows that the administrative notice could not be served upon the. So this was the first administrative notice. Could not be served upon the respondent as postal envelope was returned
So
with the end of
September 2024, another administrative notice was directed to be issued.
initially 2022
2024 order, Justice Prasad's order.
order
it showed us.
2024.
So that
This order initially records, my lord,
that awaited a report from the department. The
No,
department had said
it says under such circumstances we consider that the service is complete. After that, Justice Shen further directed an administrative notice.
no. Justice September 19, 2024 order does not say service is complete.
No, my lord, I'm not.
It says let
referring
the
to-
department supply the requisite information. If Justice Shen directed another administrative notice, that has to be culminated in a.
that wasn't that
The last position is reflected in 19 September
L-
order.
Lordship.
So after that, we have to wait for that report. The Justice Prasad's division bench said let the department supply requisite information and submit a report in that regard
My lord.
regarding the fate of the administrative notice.
Right, my lord.
Report has been submitted. It has not yet service return is not yet there. There is no service return.
Ah,
So either we can wait for that or we can direct it to put in fresh cost so that administrative.
I shall do that.
That is what we said.
No, no, my
The
lord, I
first
shall.
option was given.
I'm-
Why waste time on these
I
things?
have-
It transpires from the office report dated January 15, 2025 that till date there is no service return in respect of the administrative notice which was issued vide memo number 4594 capital F dated December 16, 2022. Full stop. Accordingly, to expedite the matter, the appellant is directed to put in fresh requisites for issuance of administrative notice on the respondent afresh. Full stop. Next para. Such cost shall be put in, such requisites shall be put in by May 13, 2025. Full stop. The office shall, immediately thereafter, ensure that administrative notice is issued immediately to the respondent. Full stop. Next para, the matter be placed in the list under the heading to be mentioned on June 23, 2025. Full stop. The office shall furnish a fresh report as to the outcome of the second administrative notice of the last administrative notice on the before the said date. We'll have to give at least 1 month, about a month, more than a month. 23rd June it will appear. We have directed it to appear so that there is some pressure on the office to serve it.
And I tender my apologies. ma'am.
No, no.
I'm grateful, ma'am.
We are sometimes, I mean, we go too hasty. Next.
That
Yes.
continuing matter.
For the appellate.
Yes, yes. So that comparison of the different deeds and all.
Different deeds, my lord, kindly, my lord, again come to that deed. Page 70.
Page?
Lord, page 70, my lord. I'm only giving the paper book, part 2, my lord. No, supplementary. So many paper books. Supplementary.
Yes.
Supplementary affidavit, part 2, page 70.
Yes. So what is the relevant page?
Yes.
Registered deed of sale.
Yes.
No, no.
That clause 13.
Clause 13, my lord, I will be placing, my lord, several other clauses. And it starts from page 70. Kindly, my lord, up to, my lord, page 75, my lord. Those are recitals. How, my lord, there was
Yes, yes.
my lord,
Starts from 76.
76
have a number.
probate, my lord, granted, my lord, all those
Did not
things.
waste time.
How, my lord, I'm not placing those.
Come to
Kindly come-
77 now this indenture
Yes,
witnesses.
yes. Kindly, my lord, I will be placing, my lord, from the first paragraph of 76 and thereafter 77.
First paragraph 76.
Yes, my lord, very well. They have become the owners. At present, my lord, how the present
These are
owners-
not disputed facts.
No, these are not disputed.
Only
Kindly
what has
see-
been given to you and to them.
Exactly. Now, my lord, kindly see, my lord, page 77. প্রথম দুটো paragraph, first two paragraphs. And whereas the purchasers have expressed his desire to purchase the property, a southwest first floor and
This
measuring.
is your deed, Mr.
No, my lord.
There.
There, my lord, the plaintiff's wife's deed. I can place it from our
No,
deeds also.
but no,
all
no.
are same.
What we meant to say is your deed is similar.
Similar. All are similar. All are similar. Southwest first floor flat measuring about 1050 square feet, super built up area and a car parking space measuring about 135 square feet on the western side of the ground floor, situated and lying at premises number 12 Bidden Row, Kolkata 7.
No, your flat is also on the southwest side. So all these are similar.
Total 10 flats, my lord. একটাই তো building. Only partly 3-storied and partly 2-storied.
Two wings.
Two wings. The together with, my lord, the next the together in caps, then, my lord, the proportionate share of land and proportionate share.
Proportionate share is different. Proportionate share in everything, yes.
Exactly. In, my lord, they are not, my lord, distinguishing. In, my lord, ultimately 12 Bidden Row. What I wanted to, my lord,
Proportionate share, when you get a flat, you get the proportionate share in the land automatically. Otherwise, the flat will have to float. That's why it's given.
no, proportionate share, what I want.
There's a joke, Mr. Bhattacharya, in Japan, vertically, plots are sold vertically. So vertically, suppose 10 feet was sold. Now, leaving 1 feet, yes. So it's like that. Unless proportionate share is in the land is given, then they'll say that you have to float. You will have to take a
Float.
helicopter and enter your
Yeah.
flat. So that's why proportionate share of the land is also given. This does not, nothing hinges on this.
No, I only wanted to Miller, show your lordship what was the intention of the parties. Why, Miller? Intention was, Miller, here, Miller, from their intention will appear that there is a proportionate share in the, Miller, open space also. That will be more clear from the next paragraph.
All right.
Kindly see. And whereas the developers.
But the keyword is available. And other common facility. I mean, it is very well. You say the entire thing.
Entire thing. Now, Millard, this is, Millard, what was the intention of the
all
parties?
the schedules are also covered. More fully described in
More
first.
fully described in, yes.
So proportionate share in entire thing.
Entirety. And first schedule is entire 12 Bidden Row.
Yes.
Now, Millard, this was the intention of the parties. Now, Millard, I was reading the entire deed. Millard, usually what happens, Millard, when a development project is, Millard, going up, Millard, there is, Millard, owner's allocation. There is a developer's allocation. Now, Millard, owner's allocation is assigned to the owner. Developer sells to the flat owners. Now, here there was no development agreement. What was there was a registered power of attorney and an unregistered power of attorney. Now, Millard, along with that, I was reading, Millard, the entire deed. Now, Millard, the owner, neither the owner nor the developer retained, Millard, their portion. There was no separate owner's allocation or developer's allocation.
All right.
Therefore, what is the power of attorney? Power of attorney was given by the original landowners to the, Millard, developer to sell the property. Now, Millard, if, Millard, any portion was not, Millard, retained by the, Millard, owners themselves, Millard, the developer, who is the power of attorney holder, he cannot have a better right than that of the, Millard, or than that of its principal. Therefore, if, Millard, they do not retain, therefore, Millard, it has to be presumed, Millard, this open land was also, Millard, was ready to be sold to the, Millard, the flat owners. The Millard, power of attorney holder cannot.
They had already transferred that open portion to him.
No, Millard, it was
4 car parking spaces were already sold to him.
Not sold. Agreement for sold never culminated, and lease deed not executed. He said he was in possession through that.
Right.
Lease deed.
The title never passed.
Title never passed. Therefore, Millard, title cannot pass because the original land.
No, that coupled with tenency was there.
Tenency was there. That is their case.
Very well.
Because my understanding is, since the original landowner did not, my lord, retain, my lord, any of their thing on the, my lord, landowners, my lord, allocation, my lord, they, even if the, my lord, the power of attorney says that he is given a right to, my lord, induct tenants to execute the sale. Yes, execute
But
definitely
at
sale.
best, then he'll have a tenancy in respect of that.
Tenancy, my lord, I will be showing, my lord, the tenancy, my lord, this in this way cannot be month to month tenancy. It cannot be.
Tenancy, how is it to be? Is there any set format?
No, my lord,
You are put in possession, you pay money, that's tenancy.
my lord, kindly
Pay
appreciate.
monthly rent, that's tenancy.
To prove tenancy here,
Otherwise, exclusive possession and all those things are there.
Yeah,
Definitely.
there. My lord, but kindly appreciate, my lord, to prove tenancy, at least in this case, my first point was the, my lord, Ashish Rai was not made a party, the developer. They allege that the tenancy was, my lord, with Ashish Rai.
No, that point is there. That is a different point.
One. Number two, my lord, tenancy, my lord, again, my lord, comes, my lord, whether Ashish Rai could have at all given the tenancy.
Tenancy will come later. Let us complete this.
Very
Yes.
well, very well. And whereas the developers along with the vendors hereon have agreed to sell or transfer their right title and interest in respect of the flat measuring about 1050 square feet, more or less super built up area, and a car parking space measuring about 135 square feet, more fully mentioned and described in the second and third schedule written here under within in favor of the purchasers herein, and the purchasers herein have agreed to purchase all that self-contained flat situated in the first floor southern western side measuring about 1050 square feet, more or less super built up area, and a car parking space on the ground floor on the western side measuring about 135 square foot, more or less, together with proportionate share of land, again, and common amenities and facilities available in the new building. Here, A, B, and C is distinguished. Kindly see, proportionate share of land. It has to be A schedule, entire bidden row. B, common areas and facilities available, is the C. And flat is flat, and the garage is B. Therefore, what was sold to me was all, A, B, and whatever is mentioned in schedule C.
It is more fully, and it also continues more fully and particularly described in the first, second, and third schedule here and there. So it is qualified by that.
Yes.
Proportionate share of land and other common facilities more fully and particularly described in first, second, and third schedule. In the third schedule, item 1, it's written open paths or passage, page 83.
Yes.
Open paths or passage and driveways, save and except areas demarcated as open, covered car parking space.
Covered car parking space is our garage.
It says open and covered. Whatever that means.
Open, covered cannot be. Open means when 4 sides are open, maybe.
Covered means 4 sides are covered.
That
open
can
is
also
open to the air.
Open to
Otherwise, there cannot be a roof without walls. There can be walls without a roof.
And pillars.
Pillar, roof, whatever,
whatever.
something to support the roof.
Yes.
A roof cannot float.
No.
So if it's open and covered, then it has to be covered on the sides and open on the upper side.
Then it's just below the car parking space or just below the flats.
Not necessarily. It is in a different portion. Bishop Datta argued it's in a different portion.
There is.
So therefore, whatever you are reading, page 77, this proportionate share, everything is qualified by more particularly described in first, second, and third schedule. And that particular description in third schedule is qualified by number 1 in third schedule, which says except areas demarcated as car parking space, open or covered, whatever. So they say that that area was demarcated as a car parking. So except that area, everything is qualified this exception.
Let us see. Check the.
So whatever you read, the more open you get, it's always circumscribed by more particularly described in first, second, and third schedule. So we cannot go beyond third schedule and whatever is written in third schedule.
Yes, that is.
As per your whatever you are reading, you are relying on that only.
But
qualified by that.
I have on the last occasion relied upon 59 Supreme Court. It says So if there is Milord consistency, Milord
First
between
and second clause,
consistency,
subsequent
it's the only first.
first,
That's why I say, Milord, there
first
is
should prevail.
13, clause 13 should prevail, and clause 19 and 20 and the Milord should not prevail.
So you say the first should prevail.
Yes,
The
yes.
first is page
Yes, 13.
77. Page 77. First 77 is prior to 13.
Even if that be so,
If that prevails, then that
Then Miller
prevails over 13.
proportionate share,
If you go back to the prior clause, then it's clauses, the first two clauses in paragraph 70, page 77, which prevail, which qualifies it by the third schedule. So that should prevail then.
no, then
And
Miller
13 has to be read in that
79
context.
Habendum clause starts from 79.
You are narrating that portion. If you rely on that,
No,
choose either to
definitely.
rely on
No, no.
77.
77.
If you rely on 77, that becomes the first clause and that qualifies whatever is later.
Lord,
If you don't rely on 77, then we can look into those clauses. Then you cannot rely on this proportionate share argument. You cannot have advantage of both. Either you rely or don't rely. If you rely, this is the first clause.
Then Millard,
And this is not the habendum as you are arguing.
then
This is
Millard
just a
clause
narrative.
13 Millard argument would be
Because-
Millard a safe argument for me.
Safe argument, not only that, Mr. Bhattacharya, 77 we cannot rely on. Because this is an expression of desire.
Exactly.
That desire might not have
Culminated in
culminated
79.
yet. Right.
Culminated in
Right.
79.
Might not have culminated in its totality. Both of you desired to win. But it will culminate, it will be modified by us, that desire. So therefore, expression of interest and intentions don't govern whatever was given. Habendum clause is the
Ultimately, what I get.
So then we can give you advantage of 13. Let us come back to 13.
Yes, the purchaser's interest in the undivided portion of land as more fully described in first schedule shall remain joint with the other co-sharers of the building who have hereto before acquired or who have hereafter right, title and interest in the said building. Therefore, here Millard, first Millard is very much, first schedule is very much specific, Millard. And
Yes.
Millard, first schedule, if your lordship kindly comes, it does not qualify by the second and the third schedule.
No. Does not.
But this is what, Millard. And Millard, kindly see, Millard, and as I was, Millard, submitting before your lordship, Millard, they
Now let us come to first schedule because this clause 13 says the purchaser, let us leave nothing to chance. Sort of.
Yes.
The purchaser purchase 13 first, but purchaser's interest in the undivided portion of land as more fully described in first schedule shall remain joint and whatever. Let us come to the first schedule. What is there?
Yes.
And now that undivided interest in the land as described in the first schedule. That is the language.
Entire 12 bidding row.
Let us see that.
All that.
Land as more fully described in the first schedule is what we have to ascertain from first schedule. So what is the land as per first schedule?
12 chitaks.
Let us see that. All that partly brick built such and such and partly one storied occupied by the tenants measuring an area of such and such. So that building is measuring that area. So it is confined to the land underneath the building, not the other land. Because no other land, contrary to what you are thinking, not submitting, first schedule does not speak about the entire premises, the property. No. It is confined to all that partly brick built two-storied building measuring an area of such and such and one-storied, partly one-storied hut structure occupied by the tenants, which measures such and such, situated and lying at such and such. Therefore, it's only the structure, Mr. Bhattacharya. So whatever, so you are entitled to proportionate share and undivided share in the land underneath the structure, which is the Japan example.
Yeah.
You have to have that. Otherwise, you can be thrown out by saying that you don't have a right in the land underneath. So you float in and float out.
No, the purchaser's interest in the undivided portion is more fully described.
There is no separate land in first schedule, apart from that which is underneath the structure.
The totaling, Millard, 6 katas, 12 chitaks.
This is all that partly brick such and such. Yes, measuring an area of such and such. Totaling 6 cutters, yes.
Out, totaling 6 cutters, 12 chitaks. Out of that, Milord,
And
land,
you also say the boundary covers the entire thing.
the partly two brick built storied building measuring about 4 cutters, and the remaining must be 2 cutters, 12 chitaks. It can be, Milord, understood in that way also. Totaling is 6 cutters, 12 chitaks, building measuring about 4 cutters, and the remaining, Milord, land could be, Milord, 2 cutters,
You have
12
to read
chitaks.
something into the document then.
It's between interpretation.
This totaling an area of 6 cutters.
Milord, the land cannot exceed 6 cutters, Milord. That is, Milord,
No.
because the
সেটাই বলছে, হ্যাঁ সেটাই টোটালিং বলতে তো তাই মিন করে।
আমাদের টিটা বার কর।
Yes, Mr. Bhattacharya, we are missing out the first part. The two structures together come to 6 cutter 12. You are missing out that 4.
Yes, all that brick built.
Partly brick built 2-storied building measuring an area of 4 plus partly 1-storied hut structure measuring 212. Totaling
the
612.
art and the building is
Land যতই ঢুকাতে যাই land দাঁড়াচ্ছে।
then, Milord, there is no, Milord, open land, because that
Apart
is,
from their portion.
no, there is no current. If,
Yes, there
Milord,
is.
4 cutters, Milord,
That is not the only portion. That is not the only remaining portion. Apart from that, those 4 car parking spaces, there must be some other lands also.
Milord, that is not pleaded in the plain.
Need not be pleaded. Let us see the document itself. Why should they plead? You should plead to get something, right over something.
Say, Milord, I have nothing. Milord, they are, Milord, winning in the, Milord, in the suit does not mean, Milord, I am contesting their suit, you don't have. Although, Milord, I have a counterclaim.
In paragraph 13, clause 13, it's written, whatever is mentioned particularly in first schedule, you have right, undivided right over your proportionate share over the land comprised of that first. So first describes the property and the land underneath it, obviously. So you have undivided share on the proportionate share in the land underneath that structure.
Yes.
If there is no other land, there is no other land. Only their car parking spaces, they own it.
No,
But there apparently is something else also. You are arguing that apart from the structure and the car parking spaces, their car parking spaces, there is no other land. No. Come to schedule, second schedule,
Yes.
the answer will be there. Because it's mentioned there and or undivided together with proportionate undivided share or interest in land comprised in the said premises mentioned in the first schedule above and come after that and proportionate undivided share or interest in the common area and facilities provided to the building mentioned in the third schedule. We come to third schedule. Third schedule says
1.
there are open paths or passages and driveways, which are the other areas except areas demarcated. So there are open paths, open areas, which comprise of not land in the general sense, in the generic sense. So what is there? This 6 cutter 12 chetaks, 4 plus 2, 12. 4 is that structure, 3-story structure. Hut, partial hut is 212.
212.
Come together to 612. That is first schedule. You have undivided proportionate share in the land underneath that, as per clause 13. What remains? Second schedule. Let us come to the second schedule. Second schedule is that flat
101 flat.
along with common areas and facilities provided there, and proportionate undivided share in the common area and facilities.
In the first schedule and proportionate undivided common areas.
First schedule remains, plus you get proportionate undivided share or interest in the common areas and facilities
as stated in third schedule.
So third schedule as well as first schedule may have some foyer or some balcony, other things. And you get a specific demarcated car parking space measuring such and such on the western side. So that is what is given to you. And third schedule, which has been referred to in the earlier schedules, in the second schedule rather, is that common areas and facilities apart from that. So you get the building, proportionate share underneath, common areas and facilities within that building, outside the building, and apart from that your car parking space, Outside that, you get third schedule, common areas, including paths, passage, and driveways, 7 except his 4 car parking spaces. And rooms, water pumps, other things are there. Staircase is also there. Water tank, roof is there. So other things are there also.
Then, Milord, if your lordship kindly sees there, Milord, agreement for sale. Milord, agreement for sale, Milord, says entire all that piece and parcel of Bastu land containing an area measuring about 6 kata.
What is that? To give us the page number?
Milord, my learned senior friend had handed over, Milord, the affidavit in opposition to the order 13 and rule 4 that they have
he
not
did,
annexed.
he did.
That is unpaginated, Milord.
But this agreement was a part of the trial court records. It was exhibit A collected.
Exhibited. Yes, yes.
Yes, let us
Kindly see the schedule.
Page 3 of part 2 of the supplementary.
supplementary paper book. Which page, Mr. Doctor?
My lord, that agreement, my lord,
Yes.
page 3.
Of which part? Part 3?
Part 2,
Part
my
2.
lord, part 2 of supplementary one.
Yes. Rehabilitation agreement that. Yes, Mr. Bhattacharya. This is what was given to them.
Yes, kindly see all that piece and parcel of Bastu land containing about the
Come to the habendum clause.
Yes.
Now this agreement witnesses.
Now this agreement is agreed and between the parties here too as follows. The party of the second part approach the first parties of rehabilitating him in an area for keeping 4 cars including 20% super built up area on ground floor northern side. For that the second party agreed to pay a sum of rupees 2 lakhs only towards the total consideration amount as agreed by and between the parties there too. Number 2, the first party agreed to sell such area,
Read on.
which
Don't stop at such.
which is more fully and particularly described in the second schedule.
So you have to come to the second schedule.
Second schedule is all that 4 car parking space or area in the northern side of the first schedule, the premises together with 20% super built up area on the ground floor together with all easement and right.
So northern side,
Northern
car
side.
parking spaces. So let us take a picture of the entire
Then
thing.
it also says it shall be part of the first schedule.
Yes, first schedule is the entire thing.
Entire. Then Millard kindly see if Millard it is Millard entirety in the part of the Millard first schedule. Millard, there cannot be Millard a demarcation or Millard does not specify where.
Northern side. You are on the western side and your garage is on the your parking space is also demarcated.
Southern side.
Southern side. So you take the south and they take the north. North-south divide, typical. We speak about north-south divide. This is the north-south divide in your case.
So then Millard, if the building comes up in the first schedule, Millard, where Millard is the Millard?
You'll have to go there and find out. We cannot answer
that. They are Millard, no commission report.
You'll have to
no
go there. You
commission.
ask your client to invite you. Go there, have an inspection, have something to eat, and just look out for yourself. But the deeds, we go by the documents, and the documents clearly provide you have the south and they have the north.
This is there. Millard,
We want to convince you before closing arguments.
Millard,
We are very bad people. We want to convince you before you.
and Millard, a few portion of the evidence, Millard, if you
Absolutely.
kindly
Yes.
see, Millard, supplementary affidavit.
Yes.
77. Kindly comes to Millard, page 77, cross-examination.
Must be the first part, Mr. Bhattacharya.
The first part.
Yes. 77.
Millard Gaurav, this is PW1, what he is saying. Kindly comes to Millard, the third paragraph, cross-examination. I reside in the suit property 12 Bidden Row. The ground floor involved in the suit is
I
not.
decide we cannot get that. Wait, third paragraph.
Yes, the cross-examination then underlined.
Cross-examination, further cross-examination.
Page 71, my lord.
77 you said.
No, sorry, my lord, sorry. 71.
71 yes.
Yes.
Cross examination.
Yes, I reside in the suit property 12 Bidden Row. The ground floor involved in the suit is not residential. I reside in the first floor of the suit building. The said flats are in the name of my wife. I have 9 out of 10 flat occupiers in the said suit property.
What do you get from here?
I mean,
These are irrelevant
no,
for
no,
the
no, last line. I do not claim ownership in respect of any portion of the suit property. My lord, they claim tenancy. Now, my lord, kindly see, my lord, page 72. The second paragraph of page 6. It starts from, my lord,
yes. Second paragraph.
my lord, few lines, my lord. After, my lord,
Sure, what you are relying on.
page 14 of
We cannot waste tags.
No. Paragraph 14 of my examination, the line next thereafter.
Got it.
The original owner sold out the flats in favor of the flat owners in premises number 12 Bidden Row. Ashish Babu was the power of attorney holder in respect of, my lord, premises number 12 Bidden Row. He is not the owner. Then, my lord, kindly see, I have not registered. I have not. Yes, the last paragraph. Last paragraph. There was only one owner of the total premises number 12 Bidden Row and also in respect of the property involved in the suit. I have not seen the deed of demarcation or divisions, meets and bounds in respect of the suit property in the involved suit. The division, my lord, is
He has not
doubtful.
seen the deed of demarcation of division. Have you seen it? Your client has also not seen.
No.
Therefore,
I instructed my lawyer to incorporate in the plan that my portion is divided and demarcated without showing any deed.
how does that help you?
No, they say
His
that
advocate was a genius. Without the deed also he could draft it.
he drafted.
Then he got the deed and put it in.
No, then Millard, they say Millard, it's a divided, specifically divided car parking space.
Is this your last straw? Then we'll hear you more on this. If there are other straws, then we won't
Millard,
waste
this
time.
is Millard, two judgments. I will be referring Millard, nothing else more. Another thing, Millard. Kindly comes to page 75.
See, we have wasted one tag.
Well,
So there is nothing in 71, nothing in 72.
No, Millard,
You are fishing out evidence.
75.
Literally fishing out evidence.
That the third line, Millard, I will not cite Ashish Roy as witness from my side. Millard, this Millard is relating to my first Millard argument, Millard, regarding declaration. Millard, he was a necessary.
Ashish Roy is not necessary, Mr. Bhattacharya. Documentary evidence prevails over oral evidence. That is also well settled.
Well settled, well settled, well settled.
I'm not very confident what is well settled after the new BSA. But I think these are basic propositions.
These are
So we are not sure about what is now settled or
these
unsettled.
are Millard on
Basic Evidence Act has remained the same basically. Only cosmetic changes, electronic evidence and all.
these are the Millard things. Millard,
Ashish Roy was not. We have taken your point. Ashish Roy was not implicated as a party to the suit. We'll definitely consider that. Whether this declaration as a tenant is maintainable without Ashish Roy, without the land.
exactly.
We'll
And
definitely
he
consider.
says that I will not cite even Ashish Roy.
Yes, yes. He is very confident on that. So we'll have to consider that is one of your good, one of the arguable arguments. That whether this declarated suit can be maintainable without the landlord. That is one point.
Millard, on facts, Millard, these are there, Millard, and Millard,
On judgments.
Yes, Millard, 2 or 3 things, Millard. Yeah, on the last occasion, I, Millard, submitted before your lordship that this, Millard, although, Millard, that document was classified as, Millard, agreement for, Millard, rehabilitation of tenants. But kindly see, Millard, the document, the clauses of the documents, it is nothing but a, Millard,
Nomenclature
does not
what
matter
is
at all.
relevant?
Does
Nomenclature
not matter. Nomenclature, no. On that, no, I did not find
You
Millard.
have got a judgment on nomenclature mattering over content.
No, I will not go on that.
We
Millard,
hope we don't have that judgment.
Millard,
That day comes, it will be very difficult for us to.
yes. Millard, I was going through the judgment, Millard. The judgment, Millard, in some portions are very vague. Impugned judgment. Impugned judgment. Now, therefore, Millard, this
That
is
is the reason we'll set it aside.
classic case where
You are
Millard,
the respondent, Mr. Bhattacharya.
The counterclaim is also there. Provision of Order 41 Rule 24 will apply, subject to correction by your lord.
No, repeat it again, please.
My lord, this is a key,
Provision of
Order 41 Rule 24 where all the materials are before your lordship.
Rule 24, order for
Yes, 24.
Yes, we can decide it. We will decide it.
Definitely.
The suit was of which year? 2011.
2011.
So 14 years back.
Yes.
If we can, we will definitely decide
I
from here.
wanted to, my lord, cite two judgments on this because.
No, let us sum up your points first. One is that regarding the first point and the third point seem to be the same. In the plaint, he has not clarified tenancy under whom. And Ashish Rai is not a party.
And
so
he will not cite Ashish Rai.
Plus, he will not cite. As witness. That was in page 75.
75.
Achha, very well. This is one point. Second point is
whichever clause 13 will prevail.
What is this Order 1 Rule 10? There was
Order 1 Rule 10. They sought to add Ashish Rai, rejected, no challenge to that. Learned Trial Court had rejected the application under Order 1 Rule 10.
Then after that, how can you take the Ashish Rai point? They wanted to add Ashish Rai.
They wanted to add Ashish Rai. Court rejected that. Thereafter, my lord,
you should have considered to that. If you take this point now.
No.
They showed their bona fides. They wanted to implead Ashish Rai. Ashish Rai not impleaded. After that, can you haul them up for non-joinder?
Then, my lord,
they should have preferred a revision. And if they lost there, they should have preferred an SLP. And if they lost there, then we can.
Then, my lord.
Where do we stop?
No. Then, my lord.
Trial court, they applied for addition of party. That was rejected by the trial court. You did not concede. You opposed that application.
Yes.
Now, whether you are permitted to take this point.
Then, my lord, he should have. Then, my lord, the other point, he should have cited, my lord, Ashish. That was the question put to him. Even without, my lord, adding Ashish Rai.
Cited Ashish Rai for doing what? What would he do? The documents are before the court. Registered document author is not required to be brought.
Registered, my lord, development agreement is registered, but the those two documents are not.
Those are not registered. Yeah, author is not required to be.
The my lord, for this, my lord,
and what are the? This is the only challenge actually.
And clause 13 will prevail. 59 Supreme Court. I have already, my lord, subject to.
Yes, sir.
My lord, while reading the judgment, I could not find out, my lord, how, my lord, the documents, my lord, unregistered documents and unregistered documents marked as exhibit, admissibility point, how was never decided.
Did you raise the question of admissibility?
Admissibility, my lord. What happened in this matter? This affidavit in opposition was cited to my to the defendant in witness in DW1 as it was tendered to him. Now it was asked to him, are you aware of these documents? He said, yes, I am aware of these documents. My witness, the defendant. Now, my lord, the entire affidavit in opposition along with all documents were compositely marked as exhibit. But whether it was on objection, nothing stated in the impugned order, even nothing stated on that part of the recording also. When the learned trial judge recorded evidence, nothing recorded there.
All right.
Lord, kindly see at page number 3 paragraph. In 752. Very good. Kindly comes to me, Lord, 2024. Even SCC 719. 2024 7 SCC 719 para 30.
So, doctor, you have not cited any judgment. You are the only. You have cited only one judgment till now. This is the second one.
The second.
Right.
Not even the case is, my lord.
No, no, Mr. Bhattacharya, you have
Kindly
you
comes
have an
from
arguable case, definitely.
paragraph 20.
When we hear somebody, we ask only the questions against him.
Definitely, one for clarification, it has to be.
Yeah.
28 kindly comes from paragraph 28. In the light of the aforesaid reasoning of the trial court, the admitted failure on its part to apply judicial mind, coupled with absence of the counsel for the appellant before it, when the general power of attorney was admitted in evidence and marked exhibit, a factor which weighed with the with the trial court, we have no hesitation to hold that for all purposes and intents, that trial court passed the order dated 19th October 2010 in exercise of its inherent power saved by section 151 CPC to do justice as well as to prevent abuse of the process of court, to which inadvertently it became a party by not applying judicial mind as required in terms of section 33, 34 and 34 of the 1857 Act. We appreciate the approach of the trial court in its judicious exercise of inherent power. Reference to section 58 of the 1957 Act by the learned counsel of the respondent is without substance. The clear language of the section 58 refers to the situation where an order is passed admitting an instrument in evidence as duly stamped or as not requiring a stamp for its attraction, as is evident from a bare reading of the order dated 19th October 2010. The trial court did neither hold the GPA as the duly stamped or as not requiring a stamp, and therefore its applicability was not attracted. Paragraph 30 is very important. We may not turn a blind eye to the fact that the revenue would be the risk of suffering huge loss if the courts fail to discharge the duty placed on it as per provision like 33 section 33 of the 1957 Act. Such provision has been inserted in the statute with a definite purpose. The legislature has reposed responsibility on the courts and trusted them to ensure that the requisite stamp duty along with penalty is duly paid on the unstamped and insufficiently stamped instrument is placed before it for admission in support of the case of a party. It is incumbent upon the courts to uphold the sanctity of the legal framework governing stamp duty, as the same are crucial for the authenticity and enforceability of the instruments. Allowing an instrument with insufficient stamp duty to pass unchallenged merely due to technicalities would undermine the legislative intent and the fiscal interest of the state. The courts ought to ensure that compliance with all substantive and procedural requirements of a statute akin to 1957 Act are adhered to by the interested parties. This duty of the court is paramount, and any deviation would set a detrimental precedent, eroding the integrity of the legal system. Thus, the court must vigilantly prevent any circumvention of these legal obligations, ensuring due compliance and strict adherence for upholding the rule of law.
But the trial court was upheld then.
No, then, my lord, here, my lord, yes, it has to be strictly followed. Here, my case is it was not followed.
Trial court in this case, it was appreciated by the Supreme Court.
Yes, trial court
had overlooked that. In the light of the above, they appreciated the judicial. It is stated, it is observed in para 28 that in the light of aforesaid reasoning, the reasoning being that for, let us come to para 27 also. Please read para 27.
Yes.
It was admitted in evidence and marked as an exhibit, and the trial court did not deliberate on its admissibility, much less applied its judicial mind, resulting in an absence of judicial determination.
That is what I am saying. It was
so that was appreciated. It is said that a factor which weighed with the trial court was that absence of counsel, etc. Here, not absence of counsel, you admitted that having knowledge. A factor which weighed with the trial, we have no hesitation to hold that for all purposes and intents, the trial could pass the order dated such and such in exercise of its inherent power to do justice as well as to prevent abuse, to which inadvertently it became a party by not applying judicial mind as required in terms of section 33 and 34. This was held. But ultimately, para 31, we set aside the impugned order of the High Court, finding no error in the order of the trial court.
But paragraph 30 is that it was the paramount duty and the
But after
delegation.
that, the order of the trial court was affirmed. Meaning thereby that the order of the trial court is restored.
Restored.
So
No,
the order of the trial court whereby it was admitted as an evidence for the ends of justice under 151, that was restored. After this
observation.
educative observation on. So you have to see what was done in that case.
Let me see the earlier paragraphs.
Judgment is a precedent for only what has been
Facts.
held there, the facts of the case. This was just a, what should I say? This is about reminding the courts about their duties.
Duties. My lord, then
Thus, the court must vigilantly prevent any circumvention of the legal obligations.
exactly what my point
But
is
trial court's order was restored
restored.
and appreciated.
My ratio, my lord, what I want to say, my lord, since it was admitted in evidence, whether, my lord, it should have been admitted or admission, my lord, lordship knows there was another judgment, my lord, of Justice S.B. Sinha, my lord, Bipin Shanti Lal Pachal. It says record all objections, delete at the time of delivering judgment.
We don't subscribe to that.
My lord, that was also there. My lord, frequently cited, my lord, in the courts.
Cited, yes.
My lord, what I am, my lord,
33 remains, but at the same time, Mr. Bhattacharya, 36 also has to be given some meaning. If you don't take that objection at the admission stage, 61 is there in Stamp Act. Section 61
cannot be called for in question.
does not prevent the Section 61 says this Section 36 and the other parts does not prevent the court from considering at the hearing stage whether it was sufficiently stamped. So even
Therefore,
if
there
you
is-
waive that right, but we cannot fault the court, and you cannot raise that point after in the teeth of Section 36. After you have not raised the admissibility question at the time when it was admitted as an evidence. Section 36 prevents you from taking the point.
Yes, but my lord, if your lordship, yes, kindly see, my
It is
lord,
you who are taking this point before this court.
as my lord, paragraph 30, my lord, let's fail from your lordship. So, my lord, educative, my lord, kindly, my lord,
30 is educative, but the rest is practical. And the rest deals with the facts of this case.
but
See,
ultimately,
para 27 read with say that 31. What was done?
ultimately, trial court's judgment was
Court should be more vigilant. In our case also, we will quote this judgment. Court should be more vigilant, but we appreciate what was done by the trial.
no,
We'll make a copy paste of this with or without the inverted commas as per our choice.
Another, my lord, this is the last one. বলো না গো। 2003 8SC 752. That kindly comes to, my lord, para 20.
But we must appreciate, Mr. Bhattacharya, you are trying your level best because and your learned friend, because these are all the points which can be taken in this matter, and we are not still against you totally.
Yes, my
We are
lord.
just putting our questions against you.
Yes.
Para 20,
No, 19 onwards.
19, very well, 19.
Yes. Order 13 Rule 4 provides for every document admitted in evidence in the suit being endorsed by or on behalf of the court, which endorsement signed or initialed by the judge amounts to admission of the document in evidence. This is exactly what has been done.
এই সাইডে পাঁচটা বই রাখলে না পড়ে যাবে ঠাপ করে বা উড়ে বেরিয়ে যাবে একটু সাইডে একটা কিছু একটা মোটা হ্যাঁ যা হোক একটা কিছু এর মোটাগুলো দিয়ে দেবো একটা মোটা তলায় পেতে রাখুন জাস্ট হ্যাঁ সব থ্যাংক ইউ প্লিজ কন্টিনিউ yes
An objection as to admissibility of the document should be raised before such endorsement is made, as right fell from your lordship. This is the law, and the court is obliged to form its opinion on the question of admissibility and express the same, on which opinion would depend the document being endorsed or admitted or not. Not admitted in evidence. In the latter the case, the document must be returned by the court to the person from whose custody it was produced. paragraph 20 is more important. The learned counsel for the defendant respondent has relied on Roman Catholic Mission versus State of Madras in support of his submission that a document not admissible in evidence, though brought on record, has to be excluded from consideration. We do not have any dispute with the proposition of law so laid down in the aforesaid case. However, the present one is a case which calls for correct proposition of law being made precise. Ordinarily, an objection to the admissibility of evidence should be taken when it is tendered and not subsequently. The objection to admissibility of documents in evidence may be classified in two classes. One, an objection that the document which is sought to be proved itself is admissible. My case comes under one in evidence. And number two, where the objection does not dispute the admissibility of a document in evidence but is directed towards the mode of proof, alleging the same to be irregular or insufficient. In the first case, that is in my case, merely because a document has been marked as an exhibit, an objection as to its maintainability is not excluded and is available to be raised even at a later stage or even in appeal or revision. In the latter case, the objection should be taken when the evidence is tendered and once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. This is the relevant.
What was the objection taken here? Let us see. Come to para 9. Third question is assessment register. Whether right of a temple can be negative than the mere strength of assessment register. Probably that was the one. Let us see. Ledger books and all.
Bankers Book Documents Act.
Ledgers were accepted by the court in regular procedure.
Perhaps paragraph 17 will be your lordship's answer to your lordship's query.
Their photocopy of their note was produced.
Here, Milord, admissibility due to non-stamped and
non-stamp, where is that?
No. In our case, in the present
that
case.
is the difficulty, Mr. Bhattacharya. Generally, as a proposition, this is true. This is settled. Admissibility and evidentiary value, as we call it. Admissibility and evidentiary value can be taken up at a later stage. Mode of proof has to be taken up then and there. But that depends. Suppose a secondary evidence goes in evidence without the criteria of secondary evidence being satisfied. Not a primary evidence. These things are regarding admissibility itself, not only the mode of proof. Those can be definitely taken up later. But here the bar does not come from the general proposition. Bar comes from section 36 of the Stamp Act itself. So if the admissibility depends on the insufficiency of stamp, then the source of that inadmissibility is the Stamp Act. Only the Stamp Act. The Stamp Act, if the Stamp Act was not there, that inadmissibility would not be there. If the source of that bar is Stamp Act, then you have to look into the Stamp Act for the procedure for that also. 33 of Stamp Act itself provides that it is inadmissible. 36 itself gives a right of waiver to you, and you have waived that right by not objecting at that point.
Then
so the language of 36 is that the question that is cannot be taken later.
Cannot be subsequently called
in question. You are calling it in question
without taking the objection, or if nothing is recorded, that is the whole...
Suppose, Mr. Bhattacharya, you could have a case if at the time of hearing of the suit, you argued the point, suppose, and court could under section 61 itself look into it, because 36 does not divert the court itself from look. Here we are sitting in a first appeal. If we are the trial court, You could have validly argued before us, yes, 36 I have waived, you exercise 61. We could have thought of that.
But this
Here
is,
we are sitting in judgment. Trial court did not commit a wrong in not invoking 61.
but
So
this is the subject to correction, continuation of suit, and your lordships have all powers that of a trial court, my lord.
not all powers.
Well,
Not all powers.
Not all powers.
We
my
don't
lord.
have several powers. One such power is substituting our views for that of the
True.
trial court. This was one of the plausible views because section 61 is discretionary, does not cast any mandate on the court to. Rather puts a fetter. 36 is not discretionary. 36, if you don't take that point, you cannot take that point. Cannot be called into question, negative terms. 36 is there.
Specific
So
power.
where is the wrong committed by the trial court? And it's also well settled, Mr. Bhattacharya, you cite every other day, everyone, all of us cite, that just because a trial court judgment is not right, there's a typical phrase. We cannot interfere because the trial court judgment is not right. It has to be wrong. Even if it's not right in a sense, in our view, it is not wrong also. There is a gray area in between. And this is not that gray area also. Where is the wrong committed by the trial? You admitted the execution of that document, exhibited, did not oppose under 36, you are barred now. So inadmissibility on that,
Then, my lord,
registrability you satisfy us because registrability cannot be waived.
17 Madras law.
You cannot waive the compulsory registration.
Incurable defect.
There is no section 36 in that. So satisfy us that this document was registrable. No,
I'm sorry,
judgment.
my lord, I am burdening your lordship, my lord, with so many.
No question about me.
Yeah, 1917 Madras 718. Lord, it's a very old, my lord, judgment, my lord. Kindly page paragraph. Yes, kindly comes, my lord, from paragraph 6. Although, my lord, it is not binding upon your lordship, the division bench of Madras, but may have some.
It's good to see an Indian judge in 1917
17. Yes,
authoring the judgment and a British judge being the.
accepting that.
We cannot elaborate on that. Yes, let us continue.
Kindly see,
6.
a few others could be distinguished. This was, my lord, I took it down. This was, my lord, already, my lord, referred to your lordship in an earlier matter. Mr. Mitra was referring to, my lord, I took it down. A few others could be distinguished on the ground that the defendant, without referring to the inadmissible and ineffectual document, admitted the plaintiff's right to be given a decree for a portion of the reliefs claimed by him, and the court was entitled to give such a decree if there was nothing to show that the admission was based on the defendant's acceptance of the validity of the document condemned by the legislature. See such and such, such and such. As regards, however, the remaining few cases which could not he so distinguished. For instance, the Burma case reported in such and such, decided by a single judge, learned judge who absolutely ignores the public policy underlining section 59 of the Transfer of Property Act. I need only say that I respectfully dissent from from that decision. Mr. Venkataramana went so far as to argue that even if the defendant expressly raised in his written statement the plea of the legal ineffectuality and inadmissibility of a document relied on by the plaintiff, and even if he denied in his written statement that the plaintiff was entitled to any relief whatever, the court could not give the plaintiff the relief which he could be legally entitled to if the document was legally, effectually, and admissible in evidence, provided that the defendant was honest or foolish enough to admit the genuineness of the defective document referred to in the plaint. I emphatically dissent from the proposition of law. While section 58 of the Evidence Act can be invoked where the documentary evidence about the admitted facts is shut out by the provision made in purely revenue laws, it cannot, in my opinion, be invoked to overrule the provision of non-revenue enactments, nor it can be used to bind a party who has made an admission of genuineness of a document when such admission is accompanied by the legal plea that the contract and the other parts, other facts mentioned in that document could not be relied upon by the opposite party owing to the provision of the statutory law. So, go to registration or attestation, etc. Some of the decision which rely on Section 58 of the Evidence Act have, in my opinion, ignored the provision of Section 58, which is as follows: provided that the court may, in its discretion, require the facts admitted to be proved otherwise than by such admission. I believe that by the proviso, it was intended that courts should, in their discretion, ignore such admissions only, not only when they are made collusively and fraudulently, but also when they are accompanied by pleas of legal admissibility, in evidence of the admitted facts, such as genuineness of a document and the nature of its contents, or legal ineffectuality of the transaction sought to be effected by the admitted documents, or where, if the courts acted on the admitted facts, it would be defeating the policy and the provisions of enactment based on public policy. In the present case, the defendant, while admitting the writing of the letter relied on by the plaintiff, clearly raised the plea, see para 1 in his written statement, that it was invalid for want of registration, and he further denied that the plaintiff was entitled to any of the reliefs claimed in the plain para 5 of the statement. Mr. Sajan Sir argued that Exhibit A was only a proposal to give a lease and did not constitute the agreement to give lease. However, having considered the pleadings and perused Exhibit A, I have no doubt that Exhibit A was delivered by the defendant to the plaintiffs on mutual understanding that it was to be the writing which embodied the plaintiffs on mutual the agreement then conceded between the parties. I am also not prepared to act upon Mr. Sajan's suggestion that the soundness of the decision in Naran Shetty versus Muthia survive to be referred for consideration to other full bench. In the result, I would set aside the lower appellate courts, set aside the decision of the lower appellate court and dismiss the plaintiff's suit. The parties will, the circumstances bear the respective cost of the law, and the appellant will sue. Therefore, my lord, admission, my lord, if it is otherwise registrable, my lord, it has to
accompanied by pleas of legal inadmissibility. You did not take that plea. It is not collusive. You did not take any plea of legal ineffectuality of the transaction. And there it was pleaded that it is bad because it is not registered. Anyway,
paragraph 5, my lord, if your lordship would kind enough.
7 is a culmination of 5.
Yes, my lord, also, my lord, kindly.
5 we have seen. 5 says the courts again are not usually inclined to treat enactments relating to revenue. Registration and attestation have been given a higher podium. High grounds of public policy. But that is the discussion, narrative.
If your lordship would kindly see on the middle, the after, my lord, clause 2A, the next sentence, the courts again are
have seen it.
Not usually inclined to treat enactment relating to a revenue as involving large and grave principles of public policy, and govern enactment relating to registration and attestation, my lord, of documents.
High ground of public policy,
exactly.
Yes.
Exactly. But where a document is not merely made admissible in evidence wholly or for certain purpose, as in section 49 clause C for Registration Act, but the legislature further enacts that the document not registered shall not affect the immovable property comprising thereon, or that a transaction of a particular nature in respect of immovable property generally or of a particular description can legally effected only by a document complying with prescribed condition as to the attestation, registration, etc. Such provision must be deemed to have been enacted on high grounds of public policy.
This is precisely which is not applicable in your case, Mr. Bhattacharya. Here what has been held is bars under revenue acts like Registration Act and all.
No, that can also be non-revenue, applied to non-revenue enactment.
No.
Provided, yes.
You have to understand what has been stated. No, you have not understood what has been stated. Subject to correction. There it has been stated that there are two types of provisions. One, like Registration Act, where the document cannot be looked into by the authorities or the courts. So there it's a question of admissibility. And the second category is without registration, title does not pass. It has no effect, like the Transfer Property Act. Like Section 54 of the Transfer Property Act makes a sale deed compulsorily registrable. So what the court is holding here is that the Registration Act bar regarding non-admissibility of an evidence due to lack of registration is not so absolute. Courts do not look into those so seriously because it's a bar, only the document is not vitiated. Only its admissibility is touched by that Revenue Act. But if it's a bar under Transfer Property Act, Section 54, or a similar statute, there the bar is not on admissibility. Court cannot look into it. But that it does not have any effect. The document itself, implicitly, inherently, the document is ineffective. No title passes. Then it's on a much more higher footing. And it's a matter of public policy. Court cannot look into it. If a sale deed is executed, not registered, you take a point regarding Section 49. Registration Act, you cannot look into it. Suppose the court waives it. Madras High Court says it's not so serious. But even if you did not take the point, Section 54 makes it mandatory for a sale deed. Otherwise, it would have no effect. No sale deed can be executed without registration. So therefore, the execution itself goes. That is on a higher footing. This is not such a case.
Here, my lord, what
Why do you say this is such a
my
case?
lord,
Because agreement for sale, even if it's registrable, it's not registrable under Section 54. Rather, Section 54 says no title passes by way of an agreement. Rather, it's a Section 49 bar read with Section 17 of the Registration Act.
49 subject to correction. It also says, my lord, it can be looked into for collateral purposes. Here, my lord, agreement for here, my lord, the unregistered on the basis of the unregistered.
No,
lease,
we
they
are not
saying-
on Section 49. We are the judgment you have cited is that this Section 49 bar is not so serious. The document does not go. Yes, collateral purpose is another different argument.
collateral
You
purpose.
say this is the main purpose.
This is the main purpose because
They stick a
say-
declaration of the tenancy.
exactly on the basis of that. But first agreement for sale, not my lord, they with Ashish Rai.
Mr. Bhattacharya, think before you argue. Here, the document is couched as whatever the reconciliation or
One
reinstatement,
rehabilitation of tenant.
rehabilitation.
That I say, my lord, is an agreement for sale.
Very well. If it's an agreement for sale and if they relied on that and filed a suit for specific performance, then it would be directly an evidence. Then it would not be for collateral purpose. Here they are relying on that agreement for sale to plead their tenancy.
No.
They have sought for a declaration of tenancy.
They are relying upon the unregistered lease deed for possession and my lord tenancy.
No, this document itself is there. This coupled with that.
Exactly. That
If they rely on an unregistered lease deed need not be registered. Section 107 read with Section 105 of Transfer Property Act and the judgments on that clearly say if the lease deed is unregistered, it would be constituted to be a monthly tenancy then.
is there.
Does not vitiate the tenancy. In case of sale, it is vitiated. But 105 read with 107 and the judgments on those, they say that it will be constituted to be a monthly tenancy if it's not a registered document. If it's more than 1 year. More than 1 year agreement, not a lease, not registered, constitute to be a monthly tenancy. Then what is vitiated is that it does not remain an year-to-year tenancy. That is what happens. It becomes a monthly tenancy. So therefore, it's not compulsory registrable to be a tenancy. If this was a suit for specific performance of that agreement, which they will have to ultimately probably file, they will file maybe someday. Then we don't know if the law will remain the same. Then you can take this point. Then you can take this point. Here they are relying on it for collateral purpose of proving their tenancy.
Strategy. The 29.
Reached that point and use it. Yes.
Can you 1 minute standard? This one Millard is the last one. 2008 8 SCC 564. 20.
Yes.
Maybe Millard Justice Chatterjee could throw some light here. Millard
Justice Chatterjee was the author.
authoring judge.
Yes.
Kindly comes to Millard 29 onwards, Millard, as we have already noted.
Yes, whatever you said, it can be used as a for collateral purpose.
Yes, then Millard, ultimate culmination is Millard, kindly comes to paragraph 35.
Hmm.
34 and 35, that is the ultimate Millard the transport itself. Kindly 35 Millard, in our view, the particular clause of the lease agreement in question cannot be called a Millard collateral purpose. As noted earlier, it is the case of the appellant that the suit premises was let out only for particular named officer of the respondent, and accordingly, after the same was vacated by the said officer, the respondent was not entitled to allot it to any other employee, and there was and liable to be evicted, which in our view was an important term forming part of the lease agreement. Therefore, such a clause, namely clause 9 of the lease agreement in this case, cannot be looked into even for collateral purposes to come to a conclusion the respondent was liable to be evicted because of violation of clause 9 of the lease agreement. That being the position, we are unable to hold that clause 9 of the lease agreement, which is admittedly unregistered, can be looked into for the purpose of evicting the respondent from the suit premises, only because the respondent was not only entitled to induct any other person other than the named officer.
Why was the lease agreement registrable in the first place in that case?
Oh, this was an Alipur matter. Alipur court matter.
That's why it becomes more relevant. Para 27, section 49 is discussed.
Yes.
Grade with section 107.
29 Millard ultimately. 26 is Millard.
Collateral, whether this is collateral purpose, that has to look. This has to be looked into, this judgment.
This is all Millard.
This has to be definitely looked into.
And Millard, this is
Whether
not,
this is collateral purpose or not.
and Millard, I checked up Millard, this has neither not been relied upon Millard subsequent judgments which I had.
No, we go by this judgment. But in this particular case, two documents have been produced by them. One lease agreement, one that rehabilitation agreement.
And the general power of attorney.
And the general power of attorney. So, anyway, we'll look into this. So the lease agreement cannot be looked into even for collateral purpose. But lease agreement is not compulsory registrable.
That is there, Millard, but this has.
We don't
this is
understand.
how Millard.
We will have to look into this, whether this was, in this case, some particular provision, we don't know. Section 107 has also been discussed.
Yes, paragraph 27.
That is what strikes us.
Yes.
If that is discussed, then a lease agreement is not compulsory registrable. It hits at the requirement of registration, not the collateral nature or something like that.
These are my.
Thank you. Yes, Mr. Dottu. What about registration? Even for a collateral purpose, whether we can look into this? His judgment of justice strategy.
This judgment, my lord,
I could not get time to go through it.
Neither did we.
My lord. Apart from that, my lord, here case is totally, my lord, it's a case, my lord, our case of tenancy and their case of title declaring us as trespass. So far as our case is
You
concerned,
have to prove your case, definitely.
my case is that three documents we are relying upon. One is rehabilitation agreement, which gives us right to be there, coupled with, my lord, the tenancy, my lord, the receipt and the allocation, that is, my lord, volume 1, part 2, page 2. Here the demarcation has been given specifically. And second one is the lease deed. If it is
Give us the pages.
page 2 of volume 1
Of supplementary.
second volume, part 2.
Not the supplementary.
Volume 1, part 2. Volume
The
1,
supplementary.
no, my lord, supplementary, main. Volume 1, main.
Supplementary paper book or main?
No, my lord, original, main paper.
Volume 1.
Volume 1, part 2, page 2.
Yes.
Page 1 are the rain receipts given by Ashish Rai, and page 2 is the possession notice. It specifically demarcates my portion in the northern side, Fort Corporation.
Possession notice.
Yes, my lord. Here, my lord, the sketch map is exhibited as exhibit
Possession
2.
notice does not give you a right. Does
No,
not create a
it's
tenancy.
the
It's a
rent
possession.
receipt along with the document given by the Ashish Rai, who executed their deed also.
You are relying on the rehabilitation agreement also. Rehabilitation deed,
Rehabilitation agreement,
which is at page 3 probably.
rehabilitation agreement. Before that, my lord, this sketch map is there to show, my lord, the demarcation, which was, my lord.
No, what are the
false
documents
fusion.
you're relying on? Rent receipt, possession notice, the
Possession-
rehabilitation deed, and one other lease deed also.
And the lease deed, my lord, that is also there. Lease deed, my lord.
That is page 7 probably.
Yes, that is part of
Part 2.
supplementary part 2.
Supplementary part 2 or volume.
Supplementary.
Yes, supplementary.
Supplementary part 2. This is the sketch map, my lord, is exhibit 2, my lord, exhibited document.
Supplementary part 2, that is page 7.
That is page 7.
So
Page
your
7 is the agreement for lease.
So agreement for lease of 21 years was registrable.
It is compulsory registrable, my lord, for the purpose of collateral purpose and to prove.
Why collateral purpose? Why do you say collateral purpose? This is the main purpose.
My purpose is to show that it's a tenancy. It's a document of tenancy.
That's the main purpose. Why
That is my purpose, for the purpose of my show my
What about
tenancy.
the rehabilitation deed? It's a developer's agreement in essence.
It's it's
That's compulsory registrable.
agreement for sale.
Yes.
Agreement for sale. Right now, till now, we are not claiming, my lord, that right of, my lord.
Does not depend on your claim, Mr. Dotto. If it's an agreement for sale, then it's compulsory registrable under section 17(1)(d).
My lord, if I take up the Apartment Ownership Act.
Why apartment owner? Under the Registration Act, it's registrable.
It is registrable for the purpose of Apartment Ownership Act also. If I can claim, my lord, over the any right under that act also, even if it is not registered.
This is not an Apartment Ownership Act scenario at all. That act is not applicable here. So let us forget other acts. Under Registration Act, it is registrable. So for collateral purpose also, why should you look into it if it's why should you look into the clauses of it?
Well,
you go through Justice Chatterjee's judgment, the relevant portions. We'll come back in 5 minutes and answer us. That why should it be looked into even for collateral purpose if it's compulsory registrable?
That last judgment. Yes.
Yes, Mr.
My lord, here in 2008 Supreme Court cases, my lord, here the facts are totally different. Here the landlord who entered into a lease agreement with a company for the purpose of my lord, putting my lord, tenancy for his employees. A particular employee was in possession. Thereafter, he retired or transferred. Subsequent, my lord, the employee came into possession as a tenant. The landlord filed the suit for eviction on the sole ground that it was given for a particular purpose of a particular tenant. And when that person goes, so you have no right to give it to someone else. So in that case, he relied upon certain clauses of the lease agreement apart from the other grounds of tenancy. It's a violation of that clauses. On such occasion, the Supreme Court came to the conclusion that you are giving tenancy by virtue and claiming that also by virtue and through that agreement for lease. So in that case, since you are relying upon your whole and sole case solely upon that, so section 47, 49 will come into play. And in that case, that clause you can only be relied upon unless it is registered.
If you are correct, the Supreme Court held that even for collateral purpose, if you rely on the clauses, then it has to be registered. Otherwise, you cannot even read.
Each and every fact, my case has to be looked into the facts given there, my lord. They are all whole and only document they have relied upon that particular clause to prove their case. But here the case is totally different. The landlord is totally relying upon the clauses of the lease deed or lease agreement for the purpose of evicting the tenant.
Please come to para 35 once.
My
Before
lord.
that, kindly see para 30.
Para 35, please come to para 35 once.
The particular clause of the lease agreement in question cannot be called a collateral purpose. As noted earlier, it is a case of appellant that the suit premises were let out only for a particular named officer of the respondent.
As you said. As you said.
And after
Next
some-
sentence, it starts from therefore, the last word there.
Therefore,
Such
liable
a clause, namely clause 9 of the lease agreement, cannot be looked into, even for collateral purposes, to come to a conclusion that the respondent
was liable to be evicted because of the violation of. So their case is wholly depending upon that
But the court
particular
held that
claim.
even for collateral purposes, terms of the clauses of the agreement cannot be looked into.
Here, my lord, there are not only one.
You are not relying on the clauses of the rehabilitation agreement. You are relying.
I am relying upon the lease deed. It's not a lease deed per se. My case is that it's an agreement for it. If it is not registered also, it can be, my lord, my lord, held. There is a monthly tenancy. That is what
that rehabilitation agreement.
My lord, that lease document. That
The other lease document.
other lease document.
Yes,
that
there we are prima facie with you.
That is coupled with, my lord, the rehabilitation agreement which has been referred at in that particular lease deed.
So therefore, even without relying on the particular clauses of the rehabilitation agreement,
lease deed.
No, even without relying on the particular clauses of the rehabilitation agreement, you rely on the lease deed coupled with the rent receipt.
Rent receipt along with, my lord, the unregistered my lord, development agreement whereby the landlord, all the landlords gave power to the Ashish Rai to come to a negotiation for the purpose of the development. My lord, has each and every case, my lord, it says to be, one cannot, in a blind eye, we cannot rely upon in such a way.
Know that in every case we have to look into the what are the facts, what is the distinction in the facts of your, why do you rely on the rehabilitation agreement?
Case is that,
Mr. Dattu, why are you relying on the rehabilitation agreement then?
Why I'm coming to that, my lord. My case is that I am a subtenant initially. That agreement I have relied upon the original tenant and the subtenant, my client, the Chittoranjan Das. But that subtenancy, my lord, that has been, my lord, corroborated by the subsequent act of the original owners by, my lord, allowing the Ashish Rai to so that he can negotiate and he can give the tenancy to someone else for the purpose of development. The main purpose was purpose of development, and that is why those two parts were demarcated otherwise. Thereafter, my Ashish Rai gave tenancy, gave receipt, rent receipt. But if I take only the rent receipt even, but that will establish my case of tenancy. A rent receipt given by my client being a tenant paid the rent to a person who is authorized to be a landlord by the original owner. But I need not to look into any other document. That will prove my case. What I am on, because it is a complete case we have to be looked into. But a person who was in possession, a property is to be developed.
Yes.
That is why for the purpose of protection, well, all these documents have been entered into, and subsequent dispute to be looked into and to be keep in someone's mind. That is why in all the deeds by the same person, it has been kept separate, so that there should not be any dispute in future. My lord, regarding the other arguments, my lord, by my learned friend, my lord, well, they have, my lord, regarding, my lord, Order 1, Rule 10, my lord, it has already been discussed. And my lord, that Ashish Roy is not a, my lord, landlord. My lord, I am not claiming my lord, tenancy against them also. It is a
No, that is their point, Mr. Datto. They say
Yes.
that you seek for a declaration that you are a tenant.
Yes.
A tenancy cannot be in thin air. It has to be in respect of a property under particular person. So you have claimed for declaration. First relief is declaration that I am a tenant in respect of the property. How can you do that without implementing the landlord? Because it is the landlord under whom you are claiming tenancy.
Well, my case
That is
the-
their point.
My case is the plaint is that I am not a tenant under whom them. It's a case that I am a tenant, and my tenancy right is trying to be infringed by those defendants.
So you say that under whoever I am a tenant, I claim my status as a tenant in respect of the property, and landlord is not infringing, but they are infringing. Therefore, they are necessary parties.
They are necessary. That is why they have been imputed as parties.
Very good.
My lord, regarding the clauses of the agreement, my lord,
Earlier clause.
earlier clause and clause 6 also, my lord, some light has been thrown. Page 79, my lord, supplementary paper book, the page part 2, my lord. Clause 6 also, my lord, regarding the latter part, the purchaser shall use the property for residential purpose, such and such and such, and shall not illegal, immoral, any purpose, public policy, and shall not deal with any business or specifically mention not deal with any business as specifically mentioned in the third schedule written hereunder.
That has nothing.
General clause.
Unless you say car parking is a nuisance or for immoral purpose.
So, and second schedule has referred to the third schedule. Second schedule in habendum clause.
This is mathematical. Actually, 13 refers to first. First, for looking at first, you have to look into second.
Second.
And it goes on like this. Second refers to third. Third excludes your portion, and so on and so forth.
And the document, my lord, regarding the interpretation of document, what we have learned in our college is Odger's, my lord, interpretation of.
You have learned in your college too. I have not learned anything in my college. Everything in practice.
Regarding the interpretation, it has to be looked as a whole. Unless there is a clear conflict between all the clauses, and that is one has
Yes,
to.
definitely. Harmonious construction.
Harmonious construction has to come into play.
No reply to reply. Why are you standing?
Regarding the other, my lord, judgments, I think, my lord, those are not squarely applicable.
That only one thing, Justice Chatterjee's judgment, only
That's
Millard,
a
Justice Chatterjee's judgment.
Yes.
Lordship would kind enough to Millard once go through Millard paragraph 30.
Para 30 we have read thrice. 30 leads to where we said. 30
is
leads
clear.
to 34, 35, those paragraphs. Para 30 merely says for such purpose, we have to look into what is the collateral purpose in the context of clause 9.
Context of
Read it out whether we are
yes,
saying it
yes,
incorrect.
yes. Context is paragraph 29, 30, and 34. 35.
Clause 9 seen in the context whether it's a collateral for
Yes,
collateral.
yes.
And my learned senior junior friend is trying to harp upon the apartment ownership, and why it says that even is for
Convince
the
him not to. Convince him not to. Give him the reason outside when you finish.
Great.
Hard learned counsel for the parties. Hearing is concluded and the matter is reserved for judgment. Parties. Both of you argued very well because it's a very interesting point. But
let us for a patient hearing.
No. Next. এগুলো এরকম ভাবেই যাবে Order sheet টা দেখি। Yes, yes, so
But first I showed your lordships the evidence of DW4.
Mr. Mahato, just give us a little recap
I suit for partition.
because we are still in clause 9. Suit for partition, you are the plaintiff.
I'm the
Very
plaintiff.
short, we'll recollect. Just
Plaintiff, my lord, my main contention is that the
suit was dismissed.
suit has been dismissed for non-joinder of necessary parties.
Hmm.
And my lord, my prayer that the two deeds exhibit G no, in respect of Schedule B and Schedule D are, my lord, by obtained by practicing fraud and by misrepresentation.
By those deeds, what happened? Who?
My lord, my predecessor has transferred the property in favor of the defendant number 1, and my lord, by another deed in favor of the defendant number 2.
All right.
My lord, my specific contention is this, my lord, so far the two deeds are there, but my lord, my specific contention is so far the deed described in Schedule D by 1 in respect of Schedule D, my lord, those have been transferred by, you have to have a deed of gift by my husband, the plaintiff number 1's husband, in favor of the defendant number 2. I am harping on that point. So for the other deed, my lord, that has been executed by Bimala, wife of another brother. My lord, I am not on that.
But you have challenged that in the suit also.
Yes, yes.
You are not pressing that.
But they were both
Officially, unofficially, or not.
officially, both are there, but I am not waiving my right. But so far this deed, my lord, I am harping.
Your quarrel is mostly with defendant number 2. Defendant number 2's deed. One's deed. That you are disputing. And Mr. Rai must be appearing for defendant number 1.
1 and 2.
One and
Oh, both.
husband, wife.
Oh, very good.
My
What
lord,
is your point, Mr.
my
Mahato?
lord, the defendant number 6, he is another brother. My lord, the so far genealogical table is concerned, my lord, if your lordships kindly come to page 17, my lord, it get the genealogy.
You have given a separate sheet
Yes,
also.
Mr. Rai has given.
Mr. Rai has given.
My lord, the genealogy has been described, Samapodo and
Page 17. This is taken from page 17, Mr. Rai.
almost same, almost same.
Almost.
So far
The moment
genealogy,
you say almost, it's.
so far genealogy same, genealogy same. My lord,
Yes, there has been additions here.
Yes.
This is better in fact. The years have been given.
my lord, Akhoy is the original owner.
Yes.
Two sons, Samapodo and Avinash. My lord, Samapodo, from Samapodo we have come. That is, my lord, defendants and the plaintiff and the defendants. Samapodo had 3 sons and 3 daughters. Umapodo, Ramapodo, Vishnupodo, 3 sons. My lord, I am coming from Ramapodo.
Yes.
And Ramapodo is the defendant number 1 and his wife is the defendant number 2.
Ramapodo is plaintiff number 1.
Ramapodo is, my lord, husband of the plaintiff number 1. Sumati Pahadi's husband is
very
Ramapodo.
Very good.
Therefore, we have come from, my lord, Ramapodo. We are claiming the share of Ramapodo as well as the
All the plaintiffs are the present appellants.
my lord.
Well, so P1, P2, P3, P4.
My
So Sumati and her 3 children. Very good.
My lord, my contention is the Ramapodo has the deed by which Ramapodo transferred his purchased property in favor of Umapodo, that is disputed. I am disputing that. And my lord, therefore, the Vishnupodo has adduced evidence as DW4. He is, my lord, defendant number 6. My lord, in my understanding, my lord, he is an independent witness. Because by virtue of this deed, the Ramapodo transferred in favor of, my lord, Umapodo, he has nothing to say. He will not be benefited if it is given to me or if it is given to, he has no heir. Therefore, Vishnupodo's evidence is, my lord, independent in my understanding.
He is DW1.
DW4.
4.
His evidence is at page 100. But he also filed the written statement independently. His written statement is at page 43 to 52. But his deposition is at page 100.
Yes.
Now, this is the affidavit in chief. If your lordships kindly come to specific portions, page 101, paragraph 8 onwards. Ramapodo, that is my predecessor, was very simple person and was a man of cool temperament. He used to believe the defendant number 1 being his elder brother and the defendant number 2 being the wife of his elder brother. Ramapodo died of the attack of cancer, leaving plaintiffs in a very rigid conditions. The plaintiffs became helpless and almost destitute. On the death of Avinash and Bimala, Avinash is the, my lord, brother of Shamapodo.
Yes.
Brother of Shamapodo.
Hmm.
That is my uncle.
Hmm.
The Ramapodo died at suggestion. On the death of Avinash, paragraph 10, and Bimala, the share of Avinash in B schedule property was inherited by the children of Shamapodo, that is the defendant number 1, Umapodo, Ramapodo, since deceased, myself, and the defendant number 3, suggestion. Therefore, so far B schedule property, he has some share, according to him. But 11, the defendant number 1 managed to get a deed of gift in respect of D schedule property by Ramapodo Pahari in his favor. It was an illegal deed, and at the relevant point of time, Ramapodo Pahari was seriously ill, being affected by cancer. The said deed is vetted by fraud, undue influence, and misrepresentation. The said deed of gift being number such and such is an absolutely void deed. Ramapodo did not deliver possession of D schedule property to Umapodo. Well, kindly mark this. So far, the possession is concerned, well, it is very vital thing, because well, the learned judge has said that after the execution of the deed, Umapodo get the possession. But my lord, mutation certificate exhibited, it shows my lord much later in 2005, the execution, the mutation proceeding was initiated. Ramapodo did not deliver possession of D schedule property to Umapodo, and Ramapodo himself possessed the same till the death, and on his death of the Ramapodo, the plaintiffs have inherited the same. This one schedule is ineffective, such and such.
He was called as a witness by the defendant.
Well, he was a party. He filed independent written statement. He has also, no, well, they have cross-examined. This
That's right.
defendant was cross-examined by the defendant.
He deposed of his own.
Since he filed he was contesting the suit independently by filing
That's why
independent.
he has been added as a DW. Yes. Right.
Then, my lord, kindly come to page 103, paragraph 16. My lord, I am only placing relating to Schedule D property, that is my relating to my paragraph 16. Ramapodo was not a man of affluence. He had no much property. He had no abundant property, and there was no scope for his largesse of property. He was a responsible husband and an affectionate father. He had much love and affection for the plaintiffs. He desired to see them happily in life and to live a flourishing life and to lead a material life in the healthy and atmosphere, and he never desired to lead them to destitution and pecuniary problems. The averments in the said deed of the gift to the effect that the defendant used to take care of younger brother, or his younger brother was overwhelmed by the such and such. Kindly mark this statement. My lord, I shall show from the evidence, my lord, that this is not correct. This is in my favor. The observation of the learned judge is not correct. On the contrary, defendant number 1 never contributed anything to the family, and he was all along crafty and rapaciously person with his cunning and money grabbing attitude to Rampodo and his wife and daughters and sciences. Paragraph 19, my lord. In fact, defendant number 1 never had any courage to bring the said deed of gift in the light during the lifetime of Rampodo and even long after death of the latter. My lord, mutation proceeding was initiated much later after the death. Paragraph 21, Ramapodo during his lifetime purchased certain properties with his own money from such and such by virtue of this also exhibited not exhibit H within Moja. The same measure 65 decimals, Rampodo possessed the same exclusively till his death, and on his death, but this property has been transferred by virtue of the deed D1. That is exhibit H. Exhibit 9.
Hmm.
Exhibit, no, my lord, it is Exhibit 8. Exhibit 8.
All.
Paragraph 23, defendant number 1, Umapada Pahari started living at Bidhannagar, Midnapur town, that is away from the village, the original place of the property. These are the, my lord, in chief.
Hmm.
All are in my favor. Now, in cross-examination at page 107,
Yes.
page 108, my lord, the first line on 18/3/1988. My lord, this is the date. On the date, 5 deeds were executed. Not the only my deed. 5 deeds were executed. All deeds have, my lord, executed.
By the same executor.
No, different executor. My lord, the
5 deeds were executed in respect of the suit properties.
my lord. Syamapada Pahari and Bimala Pahari executed a deed of gift in favor of myself, that is defendant number 4, being deed, defendant number 6, being deed number such and such. On that day, deed was executed in favor of Umapada and Ramapada also. Next paragraph, my lord. I know that Umapada, Gauri, Parvati transferred their shares such and such and such. I do not know the plot number mentioned in BDF. I mentioned about BD schedule in my affidavit in chin after knowing that what is there is those schedules. I cannot say whether B schedule property belongs to Gita and D schedule property belongs to Umapada without consulting the document. I do not know whether Bimala, after one paragraph, I do not know whether Bimala Pahari transferred some more properties by virtue of the deed, exhibit 7. I do not know whether Rampada Pahari transferred property, it is exhibit 8. Not a fact, statement made in the affidavit in chief are false. Therefore, so far the cross-examination is concerned, so far the statement in the affidavit in chief has not been, my lord, in that way dealt with. Now, my lord, kindly come to the documents, the exhibits. If your lordships kindly come to page 15, it is the first deed, my lord, executed on 18th of March 88 and, my lord, registered on 21st of March 88. My lord, all 5 documents, exhibit 6, 7, 8, 9, and, my lord, exhibit F. All 5 documents have been, my lord, executed on 18th of March 88 and, my lord, registered on 21st of March 1988. My lord, therefore, my lord, there was scope of misrepresentation and there is a scope of fraud. Now, my lord, I shall place the judgment. So far, the property, the schedule property is concerned. 110.
Yes. So you say there could have been some confusion because so many deeds were being executed.
Yes.
Might have been one deed.
Yes.
Very
This is the misrepresentation. Issues are at page.
Where is your deed, Mr. Mahathir? Sorry, the deed which you are.
Exhibit 8, page 34.
Where is it annexed in the paper book?
Page 34, my lord, of the second part. Exhibit 8. When I place the judgment, I shall, my lord, rely upon the schedule of the. Issues are at page 123.
Yes.
My lord, relevant issue is, my lord, issue number 4. Do the plaintiff have any right, title, interest over the suit property? So far limitation is concerned, my lord, issue number 3, it has held that it is not but by limitation. At page 127. So for issue number 1 and 3, I hold that the suit is duly maintainable and is not barred by the limitation. Therefore, it is in my favor. So far issue number 4 is concerned, my lord.
Yes.
My lord, so far schedule A, C, I am not relying upon that. Because, my lord, it is already some observation in my favor. And, my lord, on the last occasion of the view, the appeal may be remanded back to decide on those properties.
Subject to hearing.
Yes, yes. My lord, so far schedule B, D, and F, it, my lord, kindly come to page 132. Regarding schedules B, D, and F properties, I am going to discuss about the landed properties comprised in the above 3 schedules jointly, as they mostly have the same plots. Suit plot number such and such are common in all the above 3 schedules. Plot number 184 is also common for schedule B and F, but the same is not incorporated in schedule D. Whereas plot number 159 does not find place in schedule D and F, but the same is incorporated in schedule B, as stated above. The plaintiff have pleaded that B schedule properties belong to Bimola Pahari and it was inherited by the plaintiffs and defendant number 1326 on her death. The plaintiffs have not stated, because, my lord, the Bimola died issueless. Therefore, the brothers and their heirs have got it. The plaintiffs have not stated in their plaint how late Bimola Pahari acquired such property. The plaintiff have also claimed that D schedule property exclusively belonged to late Rampada Pahari, and on his death, the plaintiff inherited such property and are exclusive owners thereof. Again, plaintiffs have not stated how late Rampada Pahari acquired D schedule property. In respect of F schedule property, the plaintiffs have claimed that late Rampada Pahari purchased such property and the plaintiff inherited it from him on his demise. Detail of such purchase has not been given in the plaint. Defendant number 1 and 2, on other hand, have categorically stated that the properties comprised in BDF, except plot number 159, which is part of schedule B, either earlier belonged to Narendranath Panda and others. They sold out such properties in favor of Bimola Pahari, Ramapada Pahari, and the defendant number 2 by 3 deeds. Therefore, although I have not stated in the plaint, but it has been explained by the defendant. Therefore, it is admitted.
Unless they admit, how can they rely on the guilty?
Yes. Therefore, it is not disputed that my predecessor Ramapada acquired the property by virtue of a sale deed. It is his self-acquired property. Subsequently, Bimola Pahari transferred portions so purchased in her favor of the defendant number 2 by executed deed of gift 1041, that is, my lord, exhibit 7. Again, let Ramapada Pahari transferred the portion so purchased by him in favor of defendant number 1 by registered deed such and such. It is, my lord, exhibit 8. These 2 deeds of gift have been claimed by the plaintiff to be fraudulent and not binding upon them. I shall venture to discuss about the validity of the said 2 deeds later. Therefore, the learned judge has said subsequently he will deal with.
Bimola's deed you are not so much harping on now.
Madam?
Bimola's.
No. Here, my lord, the learned judge has said that so far these 2 properties he will deal with later. Now, my lord, kindly come to.
Yes, you can agree with him. Yes.
Page 135. My lord, I am only placing the relevant portion.
Yes,
There is a long judgment, man.
Please don't. If Mr. Rai wants, he can place the other portions if those are relevant to you.
Page 135, last 2 paragraphs. I further find that descheduled property mostly matches with the description of the property purchased by Ramapada Pahari by Exhibit H, which with the following exceptions. If your lordships kindly come to the Exhibit H, it is at page 123 of the second part. My lord will get the schedule at page 131. Well, these properties were purchased by Ramapada by his own money. Therefore, it is not the ancestral property. The deed starts at page, my lord, 123. Total land is, my lord, 52 decimals. It has been purchased by Ramapada Pahari, page 123, from Narendranath Panda. It has been admitted by the defendant number 1. Some exceptions, my lord, the learned judge has indicated that by Exhibit H, Ramapada Pahari purchased 7 decimals of land in plot number 184, but such plot has not been comprised in Schedule D of the plan.
He might have gifted a portion.
But my for the
Or may have purchased the larger property, but given only a part.
is not disputed because, my lord, by the virtue of the deed, Exhibit 8, I have my Ramapada transferred in favor of my lord Umapada. This plot is not there. Therefore, it has not been improved.
Yes.
Therefore, it is not.
He has the choice.
Therefore, my lord, these observations, A and B, are not relevant, my lord, for this reason. Now, my lord, kindly come to page 137. Regarding validity, second paragraph. Regarding validity of B1 and D1, it should be, it is typographical mistake. It might be mentioned as C1. It should be D1. Regarding validity of B1 and D1 schedule deeds, as discussed above, the plaintiffs have seriously disputed the validity of B1 and D1 schedule deeds executed in favor of the defendant number 2 by late Bimala Pahari and in favor of the defendant number 1 by Ramapada Pahari respectively. The plaintiffs have claimed that both the deeds are vitiated by fraud, misrepresentation practiced by the defendant number 1 upon the respective executors. The learned advocate for the plaintiff during the course of argument has submitted that the plaintiffs were never burdened to establish the absolutely that the deeds are vitiated by fraud. They had only the burden to show that the circumstances and the execution of the deed were not reconcilable, and the defendants had the burden to show that there is no shadow regarding to execution of deeds. He further argued that in the old school of Hindu family, Borda had a special status. He is respected by all family men and would be given the control of all family affairs. He further argued that the defendant number 1, being the eldest brother, had such status of Borda. He also had acumen regarding property affairs, and hence he used to look after all the family properties belonging to different members of the family, including Bimala Pahari and Ramapada Pahari. As the plaintiffs were never involved regarding management of the properties, and since they blindly relied upon the defendant number 1, they never had first-hand knowledge regarding execution of such deeds. But surrounding circumstances would speak volume of the fact that the predecessor of the plaintiff never had occasion nor any reason to transfer any property in favor of the defendant number 1, depriving his own wife and children, argued by the learned advocate for the plaintiffs. The further submission was that the evidence on record would show that late Ramapada Pahari did not have abundance of property, that he would transfer the descheduled property in favor of the defendant number 1 only, out of the respect and gratitude as stated in D1 schedule deed. Learned advocate for the plaintiff drew my attention to the fact that DW2 in his cross-examination has stated, whenever the defendant number 1 visits the village, he takes meal in his house, and his further argued by referring to such cross-examination of DW2 that DW2 was handpicked by the defendant number 1 as the attesting witness to DW1 schedule deed. D1 schedule deed, as he was a man of his confidence, such and such. Therefore, my lord, this statement written in the deed of gift that there was a good relation, he has, my lord,
Respect and gratitude,
therefore
and
he
it
has,
is meal there.
it is not correct according to the evidence of DW2. Because in his cross-examination, he has said he used to reside in Midnapur town, Bidhannagar. When he came to village, my lord, he was not usually go to the Rampado's property, Rampado's house. He used to stay with the defendant number 2. He used to take meal with the defendant. Therefore, relation was not such that Rampado, my lord, has normally executed the deed of gift in favor of the Umapado, the defendant number 1.
Who was DW2?
DW2 is, my lord, he's in the here it is say DW2, my lord, page 93.
Attesting witness to that deed.
Yes, the exhibit 8. Attesting
He was
witness
the
to
third person
exhibit.
to the family.
Relatives, married, he just stated married, he is a relative. কি relation কি আছে? No, no, DW2, DW2 a different person. DW2 is at page
Attesting
93.
witness, man of confidence. DW2 was not defendant number 2.
DW2 is Sudhanshu Shekhar Panda. Sudhanshu Shekhar Panda, he said, I am their relative. Page 93, my lord, his evidence is there.
Very
Yeah, কোথায় পড়ছিলাম?
This was the explanation for him being chosen as attesting witness.
Man.
It took meal and all. Yes.
Now, my lord, kindly come page 143. Last 2 lines relating to possession. These observations are relating to possession.
Yes.
From the above discussed evidence, it can safely be said that the plaintiffs or their predecessor interest, namely late Ramapada Pahari, have not exercised their possessory right, if at all existed, over D schedule property since the execution of D1 schedule in 1988. My lord, now kindly come to page 96 of the second volume. This is the, my lord, mutation certificate. To Umapada Pahari, defendant number 1.
Yes.
Mutation case number 2 of 2005. Deed was executed in 88. And what this certificate is issued after that. Date, my lord, so far 17 to 18, so far my understanding, 17 to 18. And my lord, the property are 191, plot number 191 and 192. These are, my lord, part of the D1 schedule deed. The exhibit 8. Plot number 191 and 92. The deed starts at page 34 and schedule is at page.
But this is in Umapado's name.
Mutation has been granted in favor of Umapado
Huh.
in a proceeding initiated in 2005 when the deed was executed in 1988. Therefore, much after the death of Ramapado.
— 1989 or 1977? That deed?
Deed 88. Executed on 18th March 1988 and registered on 21st of March 1988. All 5 deeds. Same date, execution and registration. Therefore, these 2 plots, 191 and 192 relating to mutation, in 2005, not before 2005.
They did not show any other proof of possession in the interregnum from
No,
19.
all are subsequent because this is the mutation. After that, my lord, the record of rights have been prepared. Record of rights have been produced. Tax payment receipt have been produced.
No,
all are
immediately after the gift deed, immediately after the gift deed, anything has been produced. Obviously, they come to the property, they come in possession of the property after the gift deed.
Yes. How?
So from
there is no record.
1988 till 2005, there is nothing else.
No. My lord, kindly come to page 91. This is the, my lord, tax receipt produced by them. Exhibit A. In the name of defendant number 1, Umapada Pahari. Kindly see the date, 2016. 16th February 2016. Next, my lord, in the name of Gita Rani Pahari, that is defendant number 2. It relates to, my lord, the B schedule property. It is also of 2016. My lord, record of rights prepared after the mutation. Therefore, the record of rights which have been produced as Exhibit B series, those are also after 2005 document.
Much after.
Much after. Therefore, my lord, it is the observation of the learned judge that the Ramapada Pahari have not exercised their possessory right at all over descheduled property since execution of deeds, one scheduled deed is not correct.
Have you produced anything to show that you were in possession?
Well, prior to that, in my name, the records are there. Because mutation is the, my lord, first document where from my name, the name has been changed in their name.
No, it was in all along in the name of Ramapado. Ramapado.
Yes, my lord, I have purchased the property. They have admitted that. I have purchased the property by virtue of Exhibit H. Therefore, it is in my name.
Yes. My means Ramapado's.
I have produced
name.
By virtue of the registered deed of gift executed by Ramapado, they have paid for mutation. For changing the record of rights from my name to their name. Therefore, the opinion of the observation of the learned judge that immediately after execution of the deed, they got the possession is not correct. On the other hand, defendant number 1 admittedly got his name recorded with government as possessor of such land and took the responsibility of paying taxes in respect of subsidiary since alleged date of transfer. It is absolutely perverse, man. He cannot produce any document showing payment of tax to the government immediately after execution of the transaction.
This is admittedly, this is not correct.
No. My specific case, still, my lord, I am possessing the possession. Although still I am possessing. But my lord, since the document is in their favor, from that day it can be presumed that. But till that, my lord, we are in possession. Therefore, these two observations, absolutely, my lord, perverse finding. The plaintiffs have not made any endeavor to prove their claim that such mutation was done without notice upon them. My specific case, after the service of notice, we have come about the mutation proceeding and I have taken step for this suit. The presumption is that the common practice of issuing notice of erstwhile while allowing the mutation property in the name of the transferee was followed by a public policy, public office. Such presumption is available in the terms of suggestion. Therefore, the plaintiffs came to the effect that Rampada Pahari continued possessing descheduled property, did not find a stable land to step on after scrutinizing the evidence on record, and I must hold that they have not been able to prove such fact. These are absolutely how the learned judge has come to this conclusion. I do not. It is absolutely perverse, man. Then, my lord, so far health is concerned, that has been discussed. Then B1 schedule has been discussed. Next, my lord, page 146, second paragraph. From the above discussion, it may out that the execution of B1 and D1 schedule deeds by late Bimala Pahari and late Ramapada Pahari respectively have been established. It may also presume that possession of B and D schedule property were handed over by them unto the defendant number 1 and 2 respectively, as the said fact is specifically embodied in the recitals of the said 2 deeds specifically. It is usually, my lord, in all deeds these averments are there. But by that averment, my lord, it cannot be said that I given the possession and they are in possession, they are paying government taxes. My lord, the learned judge has come disbelieved this document or accepted these documents, disbelieved my contention. On another aspect, my lord, according to the learned judge, my lord, the property by the 5 deeds, property has been partitioned to all the parties properly. My lord, that has been discussed, my lord, page 146, third paragraph. I have already discussed above that it could not be proved by the plaintiff that the Ramapada Pahari had any physical or mental impairment at the time of execution of D1 schedule deed. There is no evidence whatsoever regarding the physical and mental circumstances of Bimala Pahari. It appears that the properties that were transferred in favor of the defendant number 1, 2 were comprised in plot in which the defendant number 1 and 2 are already holding properties by virtue of the sale deeds, which they have marked as Exhibit G. It is not correct because, my lord, so far the deed of gift in respect of descheduled property by Ramapada are not by Exhibit G, it is by Exhibit H. Ramapada got that. It is, my lord, Bimala got that. So far Exhibit G, Bimala got that property. But so far Exhibit I, the Ramapada acquired title by Exhibit H.
So that is what he is saying, that defendant numbers 1 and 2 are already holding properties by virtue of sale deeds.
It is not
Exhibit
correct.
G, by virtue of Exhibit G and Exhibit J, defendant numbers 1 and 2 are not holding property.
Well, it may be instead of J, it should be H. If it is that, in that Exhibit J, instead of J, it should be H. It should be H. In that way, it is correct.
Because they were already holding.
No, Malad, in which defendant number 1 and 2 already holding properties by virtue of sale deeds. Defendant 1 and 2 did not get this property. By G and H, Ramapada and Bimala got the property.
So this logic is incorrect.
Exhibit G, my lord, Gitarani got the property from Narendra. Gitarani is, my lord, defendant number 2. My lord, kindly come to page 113 of the second part.
So therefore he is correct.
No, my lord, so far G is concerned, correct.
And J?
It is not correct.
J who has got? If it is J, my lord, I have nothing to say, but because I am not disputing that. J is Umapada Pahari. But it is not the dispute. Court is absolutely correct in saying that.
Yes, I am not on that.
You were on that before you asked you.
No, but my specific argument, my lord, in respect of Schedule D.
No, you are saying that
J and H are not related to D.
Court is on
Yes.
the credibility of the gift deed. Court says they were already holding properties there. Therefore,
No,
put
man,
in
it is
the
sale
same
deed.
plot.
Man, it is sale deeds. These are G and H, G and
Yes,
J
Court
are
says
sale
that
deed.
only.
Yes.
Court says that it appears that properties that were transferred in favor of D1 and 2 were comprised in plots in which they were already holding other lands. So they were already by virtue of the sale deeds holding lands in Exhibit G and J.
Exhibit G and G, my lord, I have committed a wrong statement before your lordship, but it is not relating to Schedule D property. Exhibit G and J are not related to, my lord, D schedule property.
Not on the same plot.
No, my lord, I am checking.
That is what the court says. It's in the same plot. That's why those were gifted to them.
Plot number 181 is not there. 181 on 182 is not there.
But
So
other
far-
plots are
So
adjacent.
for D1 schedule property, it relates to page 191 and 192. Yes, 191 and 192 is there.
Hmm.
Same plot, man. Same
Same,
plot.
same.
Same plot.
So then
Same.
this is logical.
Yes, yes.
And larger parcel was given to Ramapada. So Ramapada still has that Exhibit D6 or Exhibit M property.
That I was submitting your lordship. The property which have been purchased by me, that should not be, my lord, tagged with the family property. So for D schedule property, his purchased property by virtue of Exhibit H. That cannot be, my lord, taken to as a family property. On the other hand, other properties comprising large parcel of the land have been transferred in favor of Ramapada party by Exhibit 6, and the same has been categorized as descheduled property. It is therefore transferred that the predecessor of the plaintiffs parties would not, page 146 থেকে শুরু হয়েছে, to deprive late Rampapa, but the purchased property by Rampapa party cannot be taken to the family property. At the time of partition of the family property, my lord, those properties should not be taken into consideration.
Ramapada had other properties than D also.
No, my lord, D property is his purchased property.
Yes, but he has other family property.
Yes,
You say that his purchased property cannot be equated with the family property, that
Yes.
hotspot.
my lord, the descheduled property is his purchased property
Yes,
by
yes.
virtue of exhibit, and that has been shown, my lord, given to Umapada, the defendant number 1, by virtue of the registered deed of gift. My contents is which I have purchased, that I should not, my lord, give
That
to
cannot
the.
come within this
Yes.
fold.
Therefore, all these are, my lord, fraud and misrepresentation. He was given power, he was given authority to prepare the deeds, he have prepared the deeds at his own. All the property, even if by purchase property, has been taken into consideration.
The suit was filed when, Mr. Mahathir?
2012,
Ramapada during his lifetime did not challenge the deed.
94 he expired.
94 it was.
1988 deed was executed. So for these 6 years, he never challenged.
But after mutation, this proceeding has come.
You say the cause of action did not arise because he might.
I was possessing the land. I was relying upon him that it's all right.
Not I. You had died in 1994.
No, Maldi,
You are the
yes,
heirs of
yes,
Rampur.
yes.
Yes, because you cannot use that interchangeably.
Then, my lord, the findings of the judge at page 148. Therefore, I find no sufficient proof. Second paragraph, page 148. Therefore, I find no sufficient proof of any fraud or misrepresentation practiced by the defendant number 1 and 2 for obtaining B1 and D1 schedule deeds. The B1 and D1 schedule deeds being registered hold the presumption of valid execution with full knowledge such and such. Next paragraph, in conclusion, I hold that the plaintiffs are unsuccessful in establishing their right, title, interest over B and D schedule properties. Well, these findings are perverse according to my respectful submission before lordships on the basis of the observation, my lord, the erroneous observation which has been, my lord, I have shown to your lords.
Mr. Mahato, tell us this. Unlike a will, in case of a will, suspicious circumstance itself, it's a code of conscience. It has to look into every suspicious circumstance. In a deed of gift, if it's a registered deed of gift and 122 and 123 sections have been satisfied, gift has been taken and during lifetime it has been accepted, shown to be accepted, then can we go into suspicious circumstances to ascertain? Unless you specifically prove that fraud, because fraud and misrepresentation has to be, Order 6 Rule 4 comes in, particulars to be pleaded and proved on a more serious note. Where is the proof of fraud and misrepresentation? You are on suspicious circumstances.
Yes.
Should not have been done and all these things. But in case of a registered deed of gift, it's a registered document.
It was
Transfer
deed of gift.
we
not
cannot
ac-
equate
not
it
accepted.
regarding
Unless
accepted.
it is mutated, it has not been accepted.
So there was nothing to show that it was acted upon during the lifetime of the donor, which is 122 and 123.
It was not acted upon.
So therefore, it was not a valid
by
transfer.
filing mutation proceeding, they have not accepted it. And this was, my lord, misrepresentation that no deed has been executed in respect of those properties. And my DW6 as DW4 has stated that the deeds have not been acted upon.
Who has stated?
The defendant number 6 as DW4.
Oh, you place that.
Yes.
And you say he's independent because he
has no interest in
does not
disabled property.
have anything to gain or lose from. All right.
But that witness has specifically stated, my lord, the in fact, defendant number 1 never had any courage to bring the said deed of gift in light during the life of Ramapada and even long after the death of the latter.
Where are you reading?
My lord, page 104, it is, my lord, evidence of DW4, paragraph 19.
Yes, we are placing that. We mark that also.
This is, my lord, the case of misrepresentation that we are in possession. We are enjoying the property, therefore it is already.
So you are heavily relying on DW4, who is an independent witness, who says that it was never acted upon. And you are also relying on this mutation for the
Certificate.
first time in 2005, where 17 years
But
after the deed.
certificate issued, proceeding has been initiated in 2005, is certificate
So
subsequent.
2005, they initiated proceeding for the
The
first
tax
time.
receipts, 2016.
Even after that, to 2016, much after, everything after 2005. This is another aspect of it, and therefore the court's finding that possession was immediately taken or you did not have possession, that is also wrong. And also this justification by saying that same plot properties were transferred and all, this is not valid because it was a purchase property. Cannot be equated with
Family property.
family property. This is all.
These are my.
Thank you.
I'm
Yes, Mr. Rai.
As I have understood properly, if I have understood properly, that she is not, he is not arguing about the
Others.
others,
D.
only in respect of the scheduled property, he is arguing.
Yes.
And I indeed appreciate Mr. Mahato for not arguing that, because if he argued about the B scheduled property, the actual thing will come. So he has deliberately left that. Kindly come to my written statement with regard to the D scheduled property.
Where is that?
That is at page 28. I am not expressing others. So far as the D scheduled property where I have dealt with, I am pressing for your lordship's kind consideration. Paragraph 25.
Yes.
That the D scheduled property previously belonged to Narendranath Panda and others who purchased the same by sale deed number such and such and used to possess the same. Thereafter, this,
Yes. What?
You see, whether I should continue, it is 114.
No, not continue. But I say it is already on 14.
No, for the timing, yes, why not? We are
the-
dictated by our orderlies, not by council.
Thereafter, they sold the schedule to it should be Ramapada Pahari, the predecessor of the
It
plaintiff.
has been throughout mentioned as Rampada and Ramapada. Very.
The predecessor of the plaintiff by sale deed number such and such and gave him possession. Said Ramapada Pahari used to possess the same. Thereafter, he gifted the same to defendant number 1 by registered gift number such and such executed on 18th March 1988. At the time of execution and registration of the deed of Ramapada Pahari was physically and mentally fit and alert and had sound disposing capacity. The deed was written as per instruction of Ramapada Pahari in presence of witness, and after knowing the contents of the deed, he executed the same in presence of the attesting witness, and attesting witnesses also put the signature as attesting witness as per his direction. Say Ramapada Pahari thereafter presented the deed before the sub-register and thereafter admitting the execution registered deed of gift such and such in respect of the scheduled property. It is to be mentioned here that on 18th March 1988, Bimala Pahari executed, this is several deeds were executed in on that date. He, as I have submitted before your lordship, he is keeping with regard to the B scheduled property because that was executed by Bimala on the same date. Now, these 3 lines is important. It is to be mentioned here that on 18th March 88, Bimala Pahari executed a deed of gift in favor of defendant number 2 in presence of Ramapada Pahari and defendant number 1 thereafter on 21st. So, Ramapada was present on that date. Now,
Bimala executed a deed also in favor of D2.
D2. That he is not challenging. That is B1 schedule.
That is in favor of defendant 2. So that's why he's not.
No, he is
In the
plaintiff.
plain, in the
Oh,
plain,
sorry, right.
in plain, both the deeds have been challenged.
No, he is not arguing with regard to the B1. He is confined his
So
argument. to
Bimala's
the
gift
D.
it on the yes.
Yes. Now, kindly come to as on that date, Bimala also executed a deed. My specific statement that Ramapada was also present on that date.
Yes.
Now, kindly.
Mr. Rai will continue from here after this. from this paragraph.
My lord.
Yes. Acted upon is yes.
I was facing
Para 25 of you have just
25.
ended that.
Yes. Now kindly come to para 29 at page 30.
Yes.
I am this is somewhat the first 10-15 lines is the repetition of para 25 and I am not
Need
from
not.
your lot.
Thank you. Yes.
Kindly come to the last 7 paragraphs from the bottom. The line starts with it is to be mentioned.
Yes, it is to mention.
It is to be mentioned here that on 18th March 88, Dimala Pahari executed a deed of gift in favor of defendant number 2 in presence of Ramapada Pahari and defendant number 1. And the defendant number 1 thereafter on 21st March 88, same was registered and Ramapada Pahari acted as identifier in that deed. Now the allegation is this, that Ramapada Pahari was a cancer patient. He was not present. His signature is not there. Now, if I show to your lordship this deed, it appears that Ramapada Pahari was an identifier to the deed, which was executed. Several deeds were executed. In one of the deed, he was the identifier. Kindly come to part 2, page 32. 32. This is with regard to B1 schedule, which Mr. Mahato
not
did not argue, not challenge. Now, this is a deed by which defendant number 2 got the property from Bimala Pahari. Now, kindly come to
yes.
Next page, that is at page 33. 33, last 4 lines. আমার সত্য দখলই নিম্নে তফসিল বর্ণিত মোট 67 সম্পত্তি যার সময়োচিত বাজার মূল্য 1000 টাকা হইতেছে, উক্ত সম্পত্তি তোমার নাম বরাবর
33 there is nothing.
33 I am sorry
this is part 2. This is a supplementary paper. Yes.
Last 4 lines of the deed.
30 pagination is at the bottom.
Exhibit 8.
Exhibit 8.
Exhibit K.
No, some other page.
এইটা তো ডান পক্ষ।
32.
This is deed number 1040.
1052 is here.
These are different.
20. I am sorry. কত?
1040.
1040.
That is at page 27.
20.
27.
27. I am sorry, 27 onwards. This is a deed. The donor is
Gitarani to
Bimala Pahari and the
Bimala to Gitarani.
Bimala to my lord.
Yes.
Now, the next page.
Page.
আমার সত্য দখলই নিম্নে তফসিল বর্ণিত মোট 700 সম্পত্তি যাহার সময়োচিত বাজার মূল্য 1000 টাকা হইতেছে, উক্ত সম্পত্তি তোমার নাম বরাবর চিরসত্ব নিবিড় সত্ত্বে দানপত্র দ্বারা অর্পণকর্ত সত্যচ্যুত হইলাম। Now, kindly come to
page 32 is Ramapada Pahari's signature.
Now, Ishadi is Ramapada Pahari. So, the Ramapada Pahari was in conscious state of mind and on that date, because it is on the same date when the deed was executed in my favor by Ramapada. This is an exhibited document. Signature was also exhibited as K1. This Ramapada's signature was exhibited as K1.
Does not appear from here.
What
is that?
Second serial number 23, signature of first page of the part 2. First page of the part 2,
All.
Serial number 23. Have you kindly got it?
Yes.
My lord, signature of attesting witness
Yes.
Ramapada Pahari 151. My lord, same deed. Same deed. It was my lord, annexed again.
Yes. 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 It was K, and this was signature was K1.
K1.
Yes.
So, my lord, he was in a conscious state of mind. What has been stated that he was suffering from cancer, he can't move. My lord, that is not there. Now, my lord, if your lordships kindly see, রমাপদ পাহাড়ি সিগনেচার তারপর দেখিয়ে দিই এইটা কত বড় পাতাটাই না মানে কাইন্ডলি কাম টু মানে পেজ 40
part 2.
Part 2. Shamapada, the our predecessors,
Shamapada to Umapada.
To Umapada. Now, kindly see the kindly come at page 47. The witness is Ramapada Pahari.
No,
Ishadi, have you kindly got it? Page 47.
47.
After the name Sushil Kumar, third name Ramapada Pahari. So, everywhere Ramapada's signature was there. Now, my lord, the witness DW number 2, that is at page 93.
Yes.
So far as Mr. Mahato has read your lordship the witness numbers DW4. He was one of the brother. I do not have any good relation with him. Now, so he deposed against me in this proceedings. Although the document says.
Did you put in cross-examination that he did not have good relation with you? Because otherwise he is an independent witness.
But I want to show to your lordships that what he has stated is not correct. He stated that Ramapada was in a perfect state of mind. He was suffering from cancer. All these are false, because I have shown to your lordship the deed wherein Ramapada was an attesting witness on the same date, on 21st March 1988. So what he has been stated in that I have managed to get the deed on that date from my father because he was not in a perfect state of mind are false. So his evidence should not be taken into consideration. Now, Ramapada executed the deed in 21st March 1988. He expired on August 1994. During this long span of time, he has not took any steps for cancellation of the deed. And rather, on the date of execution of the deed, it is in the deed itself, it is written that the possession was handed over to me. And I am in actual physical possession of the same.
Regarding possession, you did not show anything.
Well,
regarding possession, you did not prove anything before 2005, which is 17 years after the deed.
With regard to the position, in the deed itself, it is written that I am handing over the position.
Let us see that deed because we have to also satisfy ourselves regarding 122 and 123 that it was accepted during the lifetime of the donor.
Yes, with regard to the deed, my lord, kindly come to my lord. Yeah. 154. Page 154. And the deed is at page 152.
Yes.
And my lord, kindly come to my lord, page 154. Done.
You should have at least furnished a type.
Yes, we should have. We
But
should
it
have.
was prepared by Mr.
But
Mahato.
although prepared by Mr. Mahato, but equal responsibility is also with us. My lord, I can't deny that.
Yes. Where have you?
দানপত্রভুক্ত সম্পত্তি সম্পূর্ণ নির্ধারণ কি আছে নিজে কস্মিনকালে আমি কি আমার ওয়ারিশগণের কেউই দানকৃত সম্পত্তির কোনাংশ কাহারও কোনো দাবি দেওয়া রইল না।
We have to be satisfied that this was either acted upon or accepted during the lifetime of the donor. In a deed, that is also one of the conditions.
But my lord, the donor was my lord, alive
till 94.
Till 1994.
So contemporaneous is something to show that it was accepted during his lifetime.
No, my lord, the documents.
Where has it been stated first? Let us complete this. That possession is handed over.
I'm. কত 154 পড়ছি না 153 153 153
Yes, স্বাধীন সত্ত্বে দখল প্রদান করিলাম.
Yes.
Page 154, fourth line from the top.
Yes. পূর্ণ স্বাধীন সত্ত্বে দখল প্রদান করিলাম.
দখল প্রদান is possession.
না নিঃসত্ত্ববান হইলাম সেটা লিখেছে. দখল প্রদান করিলাম is that
fourth line from the top.
Line from top. অদ্বৈতে আমি তফসিল বর্ণিত সম্পত্তি আপনাকে নিবিড় পূর্ণ স্বাধীন সত্ত্বে দখল প্রদান করিলাম. Similarly, the possession was handed over to me. When the paramount title
if
is
the gift deed was manufactured, then this would also be there. There is nothing independently to show that it was accepted during the lifetime.
I have shown to your lordship.
Umapada has not signed this. The donee did not sign this.
No.
Something to show that it was accepted during his lifetime. Because in gift deed, you know, Mr. Rai, more than apart from registration, also this is an additional condition. Your oral evidence may be there, must have been there. In that you said that possession was given and all.
My lord, kindly come to my lord.
If you were in possession, why did you apply for mutation in 2005, 17 years after the deed?
My lord, at that point of time, this conflict was not there. And,
but irrespective of the conflict, you have to act upon the gift deed, Mr. Rai. If you say that you did that because of the conflict, then it's counterproductive to you.
No, my lord, in the deed was, my lord, produced by me. Deed was in all along in position, in my possession.
So came from your custody. That is one of the.
Yes, it is from my custody.
Such acceptance was made during the lifetime of the book, and who are still capable of it. Acceptance like Madhuri is why পরের লাইনটা হচ্ছে ডিউরিং লাইফ টাইম আর না হলে ভয়েড ভয়েড রেজিস্টার্ড হলেও ভয়েড দেখছি সেটা কি একটা
না প্যারাগ্রাফ না আমি সাতটিটা বলছি
হ্যাঁ নাম্বার 1
জি শিডিউল প্রোভাইড
এখানে ডেলিভারি কথা মানে আনলিস্টেড হলে ডেলিভারি দিয়ে
28
হ্যাঁ
Did should be registered.
না না সে বলছে রেকর্ডিং করে মানে so far as the position which was handed over to me I have stated I'm sorry man
compulsory stable to say 123 অনুযায়ী হতে পারে ট্রান্সফার প্রপার্টি একটা একটু দিন Mr. Bray, please give us half a minute.
my lord মিউটেশনটা বলছি যে আমার রেকর্ডিং মিউটেশনটা
The transfer must be effected by reservation. For the purpose of looking at sorry, mobile. Check. তাহলে 122 শুধু আসছে 122 আসছে ভয়েড হয়ে যাবে যদি নেই because 122 says Mr. Rai that unless it is accepted during the lifetime why he could still execute the deed it becomes void
in Malad I was not shaken in the cross examination that you are not in position
let us see the cross examination on that that becomes important even if oral evidence is established and there was no counter citation or could not be shaken by credible evidence then we can go by that because we are the appellate court we cannot substitute the view of the trial court.
My lord
if you are the trial court you would be in some difficulty
Malad kindly come to Malad
yes
page 81 have you lots kindly got it
DW1
yes I am the defendant witness
you
yes
Umapad is you
yes now paragraph 30 and 31
right
I have accepted the gift of Ramapada party in respect of descheduled property and also muted the same in the present settlement in respect of descheduled property and I am possessing the same by receiving the issue flags and paying rent to the state. The plaintiffs are not in possession in the descheduled property on 21st March 1888. Shamapada and Vimala registered separate deeds of gift in favor of me and others. Now, kindly see the
Cross-exam.
cross-examination. Kindly see the cross-examination at page
90.
at page
90.
90. 90 from bottom. It is not a. Kindly come to page 92. In respect of this deed, 100,052 by 88. It is not a fact that deed number such and such has been executed voluntarily by the donor. It was procured by fraud and misrepresentation, and it was never acted upon. The denial in respect of it is not a fact that whatever I have stated in para 14, 15, 20, 21, 22, 28, 29, 30, 31, 33 to 7 are maybe which are false.
30, 31 is also there.
Yes.
General suggestion.
Yes.
স্পেসিফিক কোয়েশ্চেন নিয়ে অ্যাকসেপ্টেন্স করেনি লাইফ টাইমে এবং পজিশন ছিল স্পেসিফিক সাজেশন নেই তা নাহলে এটা চিফটা সেকেন্ড হচ্ছে না ক্যাটাগরিক্যালি বলেছে বাট মিস্টার রায় প্যারা 30 ইউ সে আই হ্যাভ অ্যাকসেপ্টেড দ্য গিফট অফ রমাপদ লাহিড়ী in respect of descheduled property and also mutated the same. Mutation was in 2005. And this is a bold statement of possessing the same.
But so far as so far as cross-examination, no question was asked whether I was in position or not, or you have not muted. Specific question has not been put in to me in cross-examination.
You have stated possessing the same by receiving usufructs and paying rent to the state.
Yes.
Those tax bills are only of 2016. 88 deed. 2016 is even after the filing of the suit.
Yes.
2005 is before filing of the suit.
My submission before your lordship is that
you got it mutated only after the dispute, Mr. Rai. That itself does not augur well for you insofar as acceptance during the lifetime.
But if the paramount deed by which I got the property, that has not been cancelled. So my title to the property is not can't be disputed.
So the gift deed.
Yes.
We are on the gift deed only.
Yes.
You got by virtue of the gift deed.
Yes.
So that gift deed.
By gift deed, I got the title over the property.
So isn't the burden on you to show that once it is challenged, don't you have to show that it was executed in terms of 122, accepted during the lifetime of
I have stated that the deed was.
You have stated I have accepted the gift that you have stated.
Yes. No, I have accepted that I have
stated during lifetime. You have stated and also mutated the name, which is only in the year 2005. Gift deed of 1988, you mutate when disputes arise in 2005, which is 17 years after.
Because there was mutation is in respect of the not a documents of title. It's is in respect of position. I was all along.
No, mutation to show that you acted upon the gift deed, you accepted during the lifetime. Where is that element of acceptance during lifetime? Otherwise, the gift deed will be void.
The specific question has not been put to me that you are not in position.
In your chief, you have not stated that I have accepted the gift deed during the lifetime of Ramapod.
A minute from your lordship.
Yes, absolutely. We know that we are making out a third case, Mr. Rai, but this is not a third case because this is a legal question. Section 122, unless section 122 is complied with, the gift deed is void. That is the effect of section 122. We have to look into that also. Void puts us on a higher footing. It's a legal by operation of law.
Although in the gift deed itself, it is written that it was handed over to me. The possession was handed over to me.
Yes, that is also there. That is also there. And as we said, our power is very restricted as an appellate court. So we won't go into that extent like a trial court. You have to see whether the necessary ingredients are there. Because a gift deed,
So far as the position is concerned, my lord, the question which was asked to me in cross-examination, it is, my lord, it is said that it is not a fact that till their death, Ramapada used to possess D schedule and Bimala used to possess B schedule property of the plaintiff. So, my lord, whether I was in possession or not, specific question was put to me. My lord, to that, my answer was, it is not a fact that till their death, Ramapada used to possess, it was definitely the question was, subject to your lordship's kind correction that till the death, Ramapada was in possession and Bimala was in possession. That I have, so with regard to the possession, specific question was that. And to that, my answer was that it is not a fact that till their fate, they were in possession of the property. That is at page 92, last but fifth line.
that is page 92.
Yes, Manoj. 92 B bottom, Manoj.
Yes, yes. Yes, that is also.
It's 67. Although, Malad, the questions which you have put to me, Malad, accepting that, Malad, the defendant, the plaintiffs in his evidence stated that she was not, didn't pay any khajna in respect of the D schedule property since 88.
What is that?
That is at page 67 in cross-examination.
That is very important.
I will kindly got it, Malad, page 67.
67.
10 lines from top. Since 1980,
Yes.
Since 1988, I have not paid khajana for D schedule property. It is a fact that Umapada Babu used to pay government rent for the said D schedule property.
But depends on the question. Difficulties in our courts, questions and answers are not maintained mostly.
But my lord, it
The question,
appears,
if the question was, since when did you not pay khajna, then this would be very relevant. But if the suggestion was, since 1980, did you pay khajna?
but my lord, on the next,
Might be that she previously also did not pay khajna at no
my
point
lord,
of.
on the next line, it is a fact that Umapada Babu used to pay government rent for the said D schedule.
What was the date of this?
This was
18/8/2016.
18/8.
Umapada has been paying from 2005. Does not mean from 88 she was. Second sentence does not say from 1988.
No,
If that
second
was
sentence,
also
but my lord,
1988,
But
clinched.
my lord, for the first sentence, my lord,
If I was the, you can understand. Right?
yes, yes.
If I
my
was the advocate, I would have asked her, আপনি কি 1988 থেকে খাজনা দিচ্ছেন?
lord. Yes, my lord, yes,
Because she previously also did not
yes.
pay.
But my lord,
Next question is,
since,
Umapada Babu কি খাজনা দেন? Yes.
yes, yes.
Being asked in 2016, and Umapada has been paying khajna from 2005, but the gift deed was of 1988.
88.
Mr. Mahato should pay us our fees. But we'll take it into consideration, Mr. Rai, definitely, because as we said, we are the appellate court, our hands are limited. So, page 67, this admission, read with the averment in the gift deed itself, plus that you were unshaken in your counter suggestion regarding the position of Ramapada continuing.
Yes.
These three things are in your favor.
My lord, there was an independent witness, that is DW2.
Whoever suits you, you are calling independent. He is calling DW Ford independent.
No, my lord, he is the
He
brother.
also did not get
He is
anything.
the brother. But my lord, the DW2 is not the brother. DW2,
Acha.
Sudhanshu Shekhar Ponda is not the brother.
He was a attesting witness to the gift deed.
Yes, yes.
So if you could manage him, then you could manage
No,
him.
my lord, not only that, my lord, in the deed which was executed in their favor, or my lord, the Sudhanshu Shekhar Panda sold the property to him.
Yes.
To
Oh,
their, my lord, my lord, the Sudhanshu Shekhar Panda was an independent, because my lord, he sold the property to
them also.
So, my lord, I want to show to your lordship with regard the evidence of Sudhanshu Shekhar Panda.
Yes.
My lord, that is at page 93. Kindly come to my lord at page 94. Paragraph 10 and 11. Ramapada Pahari gifted some property to Umapada Pahari by registered deed of gift such and the same was executed on 18th March 88. Deed was written by Shashodasha as per direction of Ramapada Pahari in presence of me and other attesting witness. After writing the deed, Ramapada personally gone through the same, and the deed written was also read over and explained to the same to Ramapada Pahari, and after knowing and understanding the same, Ramapada Pahari executed the same in presence of us by putting his signature. Thereafter, as per direction of the Ramapada Pahari, I along with other attesting witness put our signature
Para
in
12.
the para give possession of the property. I am grateful to you, Mr. Ramapada gave possession of the property of that deed to Umapada Pahari, and Umapada Pahari are possessing the same since the date of gift.
Now we are interested in the cross.
Yes.
They might have missed this in cross.
Page 96.
Page 96.
The third paragraph, Ramapada Babu executed one deed of gift in favor of Umapada Pahari. I put my signature in the said deed as witness. Then the deed was drafted on this, and then from the bottom on 18th March, 3 to 4 deeds were executed. It is a fact, last line, it is a fact, executors of all the said 3-4 deeds put their respective signature at the same time. It is fact, all witness of the said deeds put their signature at the same time. I became a witness in the other deeds also. I cannot remember the details of those deeds. Then
Yes.
Huh?
Page 97. Bottom, last sentence. Not a fact, possession was never.
Possession was never handed over to Umapada or his wife, and the possession of those lands are with Bimala and Nampada and to their legal heirs. না, এটা তো রেজিস্ট্রি অফিস, এটা তো ডিটটা নিয়ে সিগনেচার
Registration, it's a registered document. No doubt. Because
No,
we are just thinking about 122 read with 123.
my lord,
123, you know,
that's
Mr.
why
Rai.
my lord,
123 registration.
Mr. Das was my lord, requesting me to place before your lordship the evidence of from the
Registry office.
registered office. My lord, that I think that will not be
123, we are not so much concerned because that
That
is
will not
probably
be-
unshaken. It's
yes.
a registered document, there is no doubt.
Yes, yes.
But we are more concerned. These are the things which are. So first, averment in the gift deed itself. Second is this PW1 cross-examination admission. Third is your DW1, your statement and unshaken in cross-examination. And DW2 also independent witness.
Yes. Yes.
Same statement.
Yes.
And he was more categorical than you.
Yes. Yes. Yes.
Very well.
মানে so in respect of D, I the argument
Yes,
which was
yes.
made, I conclude my argument with by saying that he can't prove his title over the her title over the property. It is proved that the execution was proper and the property was handed over to me. And I am all along in position, and I have so far as the position is concerned, there is no dispute because in the cross examination I was not shaken with regard to the position, and the other witness also supports my.
And you have another argument, Mr. Rai, that fraud has not been proved. Order 6 Rule 4 also not, particulars not.
No,
there.
no, no. That
His case is fraud.
Yes.
His case is not non-acceptance and
That's why I have shown to your lordship the signature that was marked K1, that Ramapada was himself present with regard to the other documents also. So the D schedule নিয়ে বলেছে তো, আর তো কিছু বলেনি।
Yes.
That's my argument.
Yes. Mr. Mahath. If you have nothing more to add, Mr. Mahato, we can accept
In
that.
the plain,
Yes.
3, paragraph 3, I have stated, my lord, that Umapada used to look after the family property all along.
Yes.
The defendant number 1, it is my lord, paragraph 3, 8th line. The defendant number 1 is very intelligent and he had sufficient over the suit property, and during lifetime of the father Samapada and during ailment of Ramapada as well as after the death of Samapada, Umapada look after the properties of Samapada, Ramapada and other joint family property. Therefore, all along, my lord, he used to pay rent. All along, he used to take the arrange for execution of the deed, to arrange who will be the attesting witness. Everything was in the hand of Umapada. This is the specific case.
That per se does not mean that he committed a fraud. Just because it was in his hands.
This is my all along, my lord, I'm saying is misrepresentation. He has misrepresented. It is not that they, by saying that the family properties are distributed in this way, my purchased property has also been included. This is misrepresentation. And so far the possession, my specific case is at page 5D, that Ramapada did not deliver possession of descheduled property to Umapada. And Ramapada himself possessed the same till his death. This is specific case. Umapada did not accept the said deed of gift. And he did not acquire in right title interest to possession of descheduled property. These are the pleading that it has not been acted upon. He has not accepted means
Sorry, Mr. Mathur. Yes, please continue. We are here.
therefore, since I have stated in the plaint that he has not, Umapada did not accept the deed of gift. There pleading of acceptance is there.
It is there.
It is not that there is, it is not pleaded, not there.
Last quarter, no. Quarter.
In the evidence affidavit in chief, that statement is already there, page 56, last 6-7 lines. Umapada did not accept the said deed of gift, did not acquire any right title interest in descheduled property. So far the B schedule property, similar pleading, similar evidence is there. But I am not pressing on B because B schedule property is owned by Bimola. So far the property owned by my predecessor, what I can say? I can't say regarding the property owned by the Bimola. Therefore, I am not, before your lordship, I am not pressing B. There is no reason behind it that why I am pressing only for D schedule. I am not pressing for B schedule.
We couldn't understand the reason. Why?
B schedule property was owned by Bimola.
Bimola.
He has executed deed of gift, exhibit 7 in favor of Gitarand, the defendant number 2. And so far the exhibit 8, my predecessor Ramapada executed in favor of defendant.
Because Bimola executed that, you have nothing to say.
She was the owner.
Already.
I can't.
Her choice. Understood.
It is pleaded, but I am not.
You wouldn't have got the Bimola's property in any event.
Yes, 1/6 share I shall get. If it is stand that it is a void document, in that event, I shall get 1/6.
You would get 1/6.
You will also get 1/6. All the brothers and sisters will get 1/6 share.
Then you are also affected by Bimola's deed.
Yes.
But you don't have it because your predecessor, you can say.
My statement that Bimola was in possession, the Gitanagi has not accepted. It is not my.
You don't have knowledge, direct. Very.
Therefore, I have.
Will conclude arguments, Mr. Mathur.
And so far the cross-examination, therefore, so far the acceptance that pleading was there, that evidence was
Pleading
there.
was there. 122 we have taken as one of your allegations, one of your grounds also that not acted up.
So far DW1 is concerned, page 76. At page 91 in cross-examination of the DW1, tenth line from the bottom, I cannot file any document to show that at the time of recording my name in respect of the property of the impugned, notice was served upon the vendors of the deed from BLR. I shall not call any record from BLR in this regard. Regarding mutation, my lord, he has accepted that no document was shown relating to mutation proceeding.
It's a clear position that before 2005 there is nothing on record to show mutation. That is there. Only the oral evidence and the whatever is there. And the statement in the gift deed.
So far, the statement Mr. Roy has said that it is not a fact that descheduled property of the plaintiff was never transferred in my favor, and it is not a fact till their death. Ramapada used to possess scheduled property and Bimala possess descheduled property. My lord, in this respect, my lord, my submission is, my lord, he has stated earlier in his cross-examination that he has no document to show relating to membership.
No document to show. There is no document which is coming forth also.
These are key. My lord, these are my submissions.
Thank you, sir. Yeah. Your closing arguments. Sir. Thank you for being brief, both of you. Hard learned counsel for the parties. Hearing is concluded and the matter is reserved for judgment.
I'm ready.
Seven Lordship, in this matter, I am led by Mr. Partha Pratim Rai Lordship. I am praying not today, Lordship.
Not today?
Yes, he is engaged in court number Lordship 29. The other side is also engaged.
there.
Yes, in that matter, Lordship.
So they're not recording. We are not recording anything.
Yes, Lordship.
Actor order. On the prayer of the appellant, now at the time of call, none appears for the respondents. So on the prayer of the appellant, the matter is adjourned for the day.
Good.
Give your name, sir. Not Mr. Rai's name. Delete the first sentence. Yes. Both sides are here. Good. Yes.
Lord, I appear for the appellant.
You are for the appellant, right? Mr. Trivedi's moustache has been a bit trimmed.
Because it was becoming.
Don't you feel like Samson?
Actually, the growth is too big. It becomes like.
Comes.
Yes. So I look like less at the better than if I trimmed it.
Yes, sorry. Mr. Rai, please.
Well, this appeal arises out of an order passed by the learned Additional District Judge Barakpur, by which, my lord, an application under Section 13 of the Hindu Marriage Act 1955, filed by the husband respondent herein, was allowed.
Yes.
It was filed on two grounds, my lord, desertion and cruelty. My lord, this appeal has been preferred, dissatisfied with the judgment.
No, decree was granted on both grounds.
Yes. My lord, this appeal has been filed on mainly challenging that the learned judge has passed the order without considering the documentary evidence and oral evidence filed, gone before the lower court. This is number one. Number two, my lord, without considering the evidence adduced by the parties, this order was passed. And number three, my lord.
Number 1 and 2 are the same.
Same. And number three, my lord, the general judge has held that the wife has lodged 3 complaints. For that lodging of complaint, it acts as cruelty.
Well, wasn't there any finding in the trial court judgment that the lodging of complaint was baseless? There was no basis of that.
No, just only that. My lord, first I will place the judgment, then I will place the plaint and the written statement. I'm placing the judgment first. My lord, page 68 of the paper book. It starts from page 69. This is an application under Section 13 of the Hindu Marriage Act. The case of the petition in brief is that the marriage with the respondent husband was solemnized on 21/1/2010 as per Hindu rites and customs at Dakshineshwar Mahakali temple, and subsequently marriage was registered on 17/4/2010. After the marriage, the petitioner took the respondent to a matrimonial house and started to lead a happy conjugal life with the respondent. The petitioner averred that at the time of discussion regarding the marriage, the petitioner candidly disclosed to the respondent that he is a divorcee. My lord, in this regard, my lord, both the petitioner as well as the respondent are divorcees. It's an admitted fact. The petitioner further averred that from the marriage, a male child was born on 30/9/2010. The petitioner bore all the cost and expenditure regarding delivery of the child. The petitioner further averred that from few days of this marriage, the respondent denied to share bed with him and also abused the petitioner to filthy languages for which the petitioner suffered mental agony. According to the petitioner, respondent failed to pay respect to her in-laws.
Child is now 15 years old.
Yes, 14 and a half.
No chance of reconciliation.
Well, we tried one level best.
Twice the mediation has taken place, lastly by the order of this honorable court.
Mediation before the committee failed.
Yes, ma'am.
Failed, my lord.
Under the order of this honorable court.
I was not there, my lord. I have been told that the husband never came.
Sorry?
I have been told by my client.
Mr. Trivedi came instead of the husband.
No, my lord.
That's difficult.
My lord, my husband was there.
No, you need not explain that. If mediation has failed, we'll continue.
That's what I'm saying. Because now,
Not
because in view of.
You may not agree to. You have a right not to.
Yes, my lord. No, my lord. We actually it failed. There was we tried to mediate. My lord, there was efforts made, but my lord, less said the better. It was because of something else. Now it'll. I don't want to join issues on that.
My lord, according to the from page 70, according to the petitioner, respondent failed to pay respect to her in-laws and also did not hesitate in abusing old mother-in-law. According to the petitioner, respondent by ignoring the family responsibility is to rush to Kalyani court where she practiced. My lord, the appellant wife is an advocate practicing in Kalyani court.
Appellant.
The respondent
will be stricter against you because you know the law.
The respondent used to pick a fight with the petitioner on small issues and also threaten the petitioner by giving out threats that she will fabricate him in the false cases by taking advantage of her legal profession. According to the petitioner, he was subject to mental and physical torture along with rude behavior and subsequently left her matrimonial house on 14/7/2010, finding no way out. The suit was filed for divorce. On the other hand, respondent wife contested the suit by filing written statement denying inter alia the allegation and amendment as made out by the petitioner in his petition. It is submitted that the suit was barred by estoppel, waiver and acquiescence. She categorically denied and disputed the allegations made by her husband against her. According to the respondent, her mother suffered a cerebral attack on 21/12/2009 and was in coma till 15/1/2010. According to the respondent, the petitioner took advantage of the situation and obtained her consent of marriage. After marriage, as per the respondent, she was forced to bring money from her parental house and she was also humiliated, ridiculed by the petitioner's challenging and moral character. In all, the respondent highlighted that the suit is frivolous and the petitioner is entitled to decree as sought for. Now, these are the 6 issues which were framed. Is the suit maintainable in law? Has the petitioner any cause of action to file the suit? Has the respondent treated the petitioner with cruelty? Has the respondent deserted the petitioner? Is the petitioner entitled to get for decree as prayed for and other reliefs? Issue number 1 and 2, these issues were not raised by the parties at the time of argument. However, from the pleading and evidence of the respective parties, it is apparent that the relation between the two is admitted. There is no dispute to the fact that after the marriage, respondent wife moved to her matrimonial house and started living as wife of the petitioner. Issue number 3 and 4. These are the cardinal issues and hotly contested by the parties. The learned lawyer on behalf of the petitioner argued that the petitioner has duly proved his case and he and his family members are subject to torture by the respondent by taking advantage of a legal profession, has filed false and frivolous case against the petitioner. He also argued that nothing came out in the cross-examination of the petitioner from the end of the respondent, as a result of which testimony of the petitioner in the form of affidavit in chief remain established and unshaken. It is also argued by the learned lawyer for the petitioner that the evidence of the respondent will lead to conclusion that the respondent was subject to petitioner to cruelty. It is also argued that the petitioner lost his job at the instance of the respondent as she filed a complaint before the authorities or employer wherein the petitioner used to work. The learned lawyer for the petitioner cited the following decisions. I am not reading that. The next paragraph. The learned lawyer on behalf of the respondent argued that despite being a practicing lawyer, the respondent tried to maintain both practice and house simultaneously. It is also argued that the petitioner from the very inception was anxious to throw the respondent out of his house, also failed to turn up during the
We have
ceremony.
gone through the judgment. We find three things rather. Page 75, court has held that in her cross-examination, the wife has admitted that she made no endeavor to communicate with the husband since 2010. This is the best case she has. Page 75 as well as 77, court finds that 3 cases were lodged, and that itself is a cruelty, which we are prima facie with you, subject to what Mr. Trivedi says. Page 77, another thing against you, she lodged a complaint at the husband's workplace. If you had a family rift, unless it's related to the workplace, if there was an allegation he had a relation with somebody in the workplace or something related, otherwise, why shouldn't that also be constituted to be a cruelty? Because if I have a rift, I'm your wife, I have a rift with you, I may lodge complaints, definitely. There may be some basis to that also. But why should I go to your workplace and lodge a complaint? That is harassment. These things you'll have to explain.
My lord, what has happened, my lord, when I am explaining.
Filing 3 complaints itself is cruelty. We are with you on that. Other 2. Animus revertanda is absent.
My lord,
2010, she did not make any endeavor.
I will take your lordship in 2 documents.
Yes.
It is page 48 and 49, part 3 of the paper book.
There's a part 3?
Sorry, part 2 index. Index exhibit filed by the defendant, exhibit 2 and exhibit 3, page 48 and 49.
Page 48 and
49.
49.
Now, the 48 is a letter issued by the government of West Bengal that the employer of the husband.
Yes.
It's a letter dated 15/7/2011. It says, in reference to the letter as received from the staff of MGNREGS cell Howrah, as regarding complaints allegations received from Sri Kamalika Mojumdar Das for some time past, you are hereby directed to explain the facts in details. Also stating whether any court case is pending or any other order of the Honorable Court in this regard.
Yes.
And my lord, next page. 25/8/2011. It was issued to the husband, my lord, as directed by the authority, you are by informed that being dissatisfied. My lord, dissatisfied may be with his performance, not against this complaint.
Dissatisfied may not be, because it is 9 years apart from the complaint. Maybe for some other reason.
Yes. So for that reason, I'm showing this to your lordship.
Husband did not challenge this. There is no reason in this. Anyway, this may or may not be connected to the.
That is exactly what I'm saying, but this may be regarding his performance there.
Maybe.
Because it was a contractual job. His performance not good. For that reason, his contract was not renewed.
But this page 48 is there.
Yes, my lord. Why
did you go to his office and complain?
My lord, he was not at that point of time. My lord, a domestic violence case was there, filed by my client against the husband. My lord, he was called for a conciliation. He didn't appear there, and his whereabouts was not known to the wife. So he went to his office and made a complaint that he is not looking after me.
Very well. What happened to those criminal cases?
Well, that is pending. 498 is also pending.
What are the 3 criminal cases? 498A?
Two cases, man. 498 and domestic violence.
Only 2?
2. The third one, 125, he is not pursuing.
Oh, 125 is not a criminal case.
Their order has been passed and we are complying with the payment of maintenance.
That's not a criminal case.
Whatever. They've got 3 has been stated. No,
125 has also been taken to be cruelty.
No, my lord. The cruelty has been taken.
3 criminal cases.
3 criminal cases. Then I have to find out there is one more, because normally what happens.
If you could not find out till now, then you could never be.
Criminal cases are there.
Suit is of 2016. And even in 9 years, if you could not find out Mr. Trivedi, then you cannot manufacture it.
No, my lord, I am not manufacturing.
One more thing, my lord. There are 144 cases filed against by the husband against the wife.
144. So that you cannot enter that area.
Yes. And that the learned judge has held that this is also for this, that 3 cases, 1498 and these 2 cases.
No, 144 was by the husband.
By the husband.
So that is your best point, but we are on your worst point because you are arguing.
My lord,
Now
kindly
regarding
come
this,
to page 77.
yes,
At page 77, that is the judgment, part of the judgment. At this, Kamalika Das denied that she has not tried to incriminate him in false cases, but admitted she has filed 3 against, also filed miscase. These 2 miscases are filed by the husband, not by me.
Oh,
Not by, that has been wrongly recorded.
oh, this yes, proceeding. No, that is your best point. We are telling you, just because criminal complaints were lodged and cases were initiated, that itself cannot be.
And my lord, one thing, I have lodged that 498 only after when I was insulted, when I was beaten, when I tried.
That is what we are saying.
Yes,
We have
yes,
to,
yes.
because the court has to come to a finding
Yes.
that it was baseless. It was baseless. Unless court comes to a finding that there was no reasonable basis for filing those complaints. That finding is not even there. Court says by itself it is a
Since we have lodged a complaint, it's a mental.
absolutely bad law, bad in law. But the other 2, please deal with those, because this please show us your cross-examination that
My lord,
he said that
I am first taking a lordship to the plaint which was filed, that the application under section 13.
why should you take it? Please show us the evidence that plaint case has been narrated by the trial judge. We will come back if necessary for some particular purpose. You want to highlight a particular portion to show that pleadings are backed up by evidence is backed by pleadings.
What has been done, my lord? The pleadings, what has been stated, the same thing has been narrated in the affidavit of evidence. And my lord, no corroborating evidence. My lord,
in your cross-examination, you are OPW1. In your cross-examination, court says that you have admitted that since 2010 you have made no endeavor to go back to him, which can tantamount to cruelty. Desertion, sorry.
My lord, in the written statement I have said, my lord, there are two aspects here.
Yes.
My lord, there that for that reason I am showing the plaint itself. My lord, kindly come to paragraph page 5 of the paper book, paragraph 11.
Yes.
The matrimonial hope petitioner has been subject to both physical and mental torture, whimsically and capriciously. She used adamant tone gesture towards her mother-in-law, and on 14/7/2010, she violently assaulted your petitioner.
Why did you add voluntarily in your?
Well, it is their plaint, Malad.
Oh, right.
It is their plaint.
Oh, they say she violently assaulted his mother and voluntarily withdrew herself.
This is one. Malad, against the assault, no complaint was lodged in the police. Nobody was present. There somebody must be present.
No, it is not on that. It's his. Suppose you disbelieve that. Let us disbelieve that. That is not one of the grounds on which it has been done. But court says that you have admitted in your cross-examination, you made no endeavor from 2010 to go back.
Well, kindly come to my written statement.
Yes, let us see that.
Page 10. Page 10, paragraph 4. The present suit is a counterblast against the proceeding initiated 498A and proceeding under 12, 18, 19, 20 of the Domestic Violence Act and 125. Well, this is number 1. Number 2. My lord, kindly come to paragraph 10.
10 you have denied.
Denied, and my lord, in the next page, page 13.
Yes, we are there.
Not to be seen, Bhola PS, my lord, after this, the Bhola PS was false. Respondent subject to physical mental torture on 14/7. Respondent violently assaulted her mother-in-law. This complaint was lodged. My lord, act of cruelty, desertion. My lord, thereafter I went to explain what has happened actually. Well, and I am taking your lordship to that part.
Yes.
Page 18, subparagraph G. Actually, what has happened on 14/7/2010? So that on 14/7/2010, after giving shad by the petitioner and his mother, respondent was sent to stay at her parental home by the petitioner and his mother as per their custom. But they have raised the cause of action. Then on 14/7/2010, there was some dispute. The respondent, the appellant manhandled his mother-in-law and then
Assaulted and
assaulted and then went away. But actual case is this. And my lord, I will take your lordship to page 19, paragraph I. That
Yes.
after waiting for 1 month, on 10/11/2010, the respondent had filed a complaint before the protection officer Howrah seeking help to trace out the respondent and necessary steps be taken by them for peaceful marital life of the petitioner. The protection officer arranged the marital counseling. Lastly, on Atho, the petitioner was absent.
No, you can read the previous
And-
paragraph also.
Then,
Previous paragraph is also, you could not trace him out.
could not trace it. Page H, paragraph H.
Yes,
That on
yes.
13,
H is also
13/9/2000, a male child was born at Kolani due to wedlock of the respondent petitioner. On 9/10/2010, when the respondent gave proposal to the petitioner that he wants to come back with the newborn baby at Agarpara residence, the petitioner refused the proposal and told that his mother mother does not want to stay with the respondent, and her demanded has not yet been fulfilled. It will not be possible for the petitioner to desert his mother. And lastly, on 10/10/2010, the petitioner has applied for the respondent newborn baby. Respondent tried a lot to contact the other relatives along with the petitioner, but all did not receive the single phone call and cut the telephone of the respondent, and the petitioner cut telephone in connection with the office. After confirming the respondent's voice, even the petitioner, and that his mother went away from Agarpara residence by keeping the house under lock and key. On 20/10/2010, the respondent with a newborn baby went to Agarpara residence and flat at Mudungram also, but came back after seeing that the same are under lock and key. Thus, the petitioner denying all his liabilities toward the respondent and newborn baby, neglecting him. Thereafter this, and then, my lord, paragraph J. That on 11/12/2010, after getting the news that the petitioner and his mother have taken shelter in the vacant flat at Shodhpur belonged to his sister, the respondent went there with her newborn baby of 2 months and 10 days old, with high hope that after seeing the child, it may be the case will agree to live with the conjugal life, and the baby would get the love touch of the father. But when the petitioner first knocked the door of the petitioner's mother, opened the door, but when the petitioner stepped in both the petitioner and his mother started shouting, "Why have you come here?" And thereafter assaulted the wife, and the wife lodged a complaint before the court of appeals.
Yes. Let us see your evidence.
Lord, 2 letters were issued.
Does the court relies on your evidence to say that you admitted that you made no endeavor? Because there is nothing in a written statement, because the suit was filed when? Suit was filed in 2016.
2016.
Now, in your written statement, there is nothing that after this GD entry you ever made in tried to come back to him or something like that.
Well, there are two letters which were issued. But I'm showing that.
You have not stated about those exchange of letters in your pleadings.
Well, there is. Just give me some time. Let's kindly come to my affidavit of evidence, affidavit in chief. Hmm? Page 50, my lord. Page 50.
Yes.
My lord, two letters was issued. On 29/10/2010, which is marked Exhibit D, and one letter, Exhibit E. My lord, they are in the paperwork, my lord. I am taking your lordship to those two letters. Page 25.
You gave a complaint to the local club.
No, before that, this letter was issued to the husband.
Achha.
It came back with postal remark that the door closed. Thereafter, when I went there and found the under lock and key, thereafter I approached this club.
So Exhibit D is in support of your document that you could not trace out your husband because it was lock and key.
Yes, yes. For that reason, I have lodged that complaint with the office. This was not considered by the court.
Why did you write to the local club?
Because the club was situated just beside that premises which is under lock and key.
Oh, it was the club near his.
That
so you tried to I mean harass him in all possible manners.
No,
Going to office, local club.
Local
He has
club
no
means
place to go back to.
The house was locked. So I
Go
was
to the local club.
The local club was just beside that house.
And you give a written complaint to them.
No, no, they asked me what has happened. They did not.
Let us see that later.
Page 26, Marat.
26 of part 2 must be. Next page is here, translation.
English translation.
Translation আছে বেঙ্গলিটাই পড়ুন না এই মর্মটা বুঝে নিন
He has stated what has actually happened, nothing more. But the club did not interfere anything. They didn't even call for the husband or it tried to interact with the husband. Since I was not having any, so I asked them that if you are got some information, kindly share it with us, with me.
Yes, but let us see your evidence. Otherwise, where you have admitted that you did not go back to him.
We are taking your lordship to the affidavit in chief and thereafter the examination and cross-examination. My lord, affidavit in chief is starts from page 35.
Affidavit is if you are not interested because you will be repeating your plain things. There was extensive
It
cross-examination.
starts from page 49.
Extensive cross-examination.
50. I am a respondent in this case, submitted this affidavit. My lord, these are the exhibits. Thereafter, cross starts from page 51. I am an LB cross-exam deferred, then starts from page 52. It is a fact prior to the marriage, my father had an interaction with the petitioner. I also knew the antecedent of the petitioner. My father has tried his best to give good marriage to me. So far, my knowledge is my husband. So this is regarding the earlier marriage of this 50,000. I know the petitioner was a divorcee, but the fact this was not concerned because I also happen to be a divorcee. The medical bill does not conclude, my lord. Next paragraph, next page, page 54. Further cross-examination, not a fact the petitioner. During that day, I tried to contact my husband and the other relatives over phone. For that reason, I have not filed any application under section 144(2) CRPC. I have not sought help from police authority for opening the flat. I have
In
sought
your entire cross-examination, we could find only one statement which supports this contention that you did not. You have stated in page 61 in your cross-examination on 31st of August 2019 that you have document stroke letter to show that you have communicated with husband after 2010, but you have not submitted such documents at the time of filing written statement. Apart from that, we could not find out anything in your entire cross-examination that you have admitted that after 2010 you have never tried to go back, subject to what Mr. Trivedi will be showing us.
My lord, after 2010, I tried to contact over phone.
No, court proceeds on the premise. Court says there are three grounds on which divorce has been granted. One is that complaints themselves, which we are saying we are with you for the time being. Second is that you went to his workplace and complained, which you have argued on that need not necessarily have led to his dismissal much after. Third is that you have admitted in your cross-examination that there is no endeavor to communicate with the husband since 2010. But the only sentence which we find in your cross-examination is, I have documents stroke letter to show that I have communicated with my husband after 2010. I have not submitted such documents at the time of filing of written statement. Page 61. Apart from that, we could not find out any admission on your part that you did not make any endeavor to communicate. Rather, you said the contrary, that you had communicated, but adverse inference might have been drawn against you. Court does not say that it draws adverse inference. Court says you have admitted that you made no endeavor. But we find that you said that you had communicated, but you will be submitting, you didn't submit.
And my lord,
At best.
and my lord, one thing, my lord, the period of staying together started from January till July 2010. Thereafter, according to them, I went away, and according to the wife, he was taken and asked to stay with her parents. Thereafter, nothing happened.
Your case is that after that Shad ceremony, you were sent away and then never taken back. After the birth of the son, you tried to go back. You went to Sodhpur and the other place, both Agartala and Sodhpur. Agorpara and Sodhpur are nearby. You went to both places, found lock and key. You approached the nearest club. You told them your woes, gave something in writing, came back. You had also gone to his office to complain, and you had lost 3 criminal complaints. The court says you said 2. That is about all. Now, the court finds that yes, criminal complaints were lodged by you. That's cruelty 1. Second, you have admitted that you did not make any endeavor to go back to husband after 2010. And third is that this your complaint.
And my lord, the court has also held that since I have lodged a complaint with the workplace, that is also
yes, workplace. That is the third thing. The lodging complaint with the workplace. Now, there also probably Mr. Trivedi has to answer whether that by itself can be cruelty. Because a wife, if she's suffering in the hands of the husband, that's definitely an attempt to tarnish his image in his workplace. By itself, whether that can tantamount to cruelty, sufficient to grant a divorce decree.
But my lord, the application which has been filed has got some allegations. My lord, that allegation was
your application, a divorce application.
Divorce application. That allegation, what he has stated there, has came up in the affidavit, of evidence.
Yes,
But that has not been corroborated with any further evidence. Suppose I am giving, I have threatened my mother-in-law, or I have, so something must be there. Either a written complaint or somebody a written complaint by the
So
other
only
person.
the husband and the wife deposed.
Only husband and the wife deposed.
So no corroborative evidence.
No corroborative evidence. That is exactly what I'm submitting, my lord. Since no corroborative evidence was there, my lord, his application was not proved.
You still want to go back? Because if the marriage has irretrievably broken down, it's cruelty to each other. Justice Dhulia has held recently.
But still, I have already spoken to my client. He wants to go back if they are agreeable. Yes,
Will it be of any use? But Mr. So you want to cite anything, or we'll go to Mr. Thiru?
My lord, regarding citing, my lord, I will place it on the next day. I've got two judgments.
You'll get no next day. We'll conclude arguments right now. Two judgments on what is the proposition? Tell us. What is cruelty and all? We know what is cruelty right now. We have matrimonial ethics throughout the determination period.
But averment in petition and evidence record do not disclose any cruelty. That is the point what I will
Yes,
submit.
yes.
My lord, on this point, my lord, I submitting a judgment reported in Madras High Court judgment.
You couldn't find in any Supreme Court or Calcutta High Court.
My lord, this was
So many judgments.
My lord, for that reason, my lord, I've got two judgments. This is one, and I will submit another one. No. Okay, copy দিচ্ছি.
You can give us a reference of the other. Must have it somewhere.
No, it is in SCC, but I could not locate it.
What is the name of the parties?
My lord,
No, not this. The other judgment you are saying.
that is a famous judgment, my lord. I'm giving. It is
so many famous judgments from Dastane onwards.
Somor Das and
Somor
Ghosh
versus Joya Ghosh.
Joya Ghosh.
Somor Ghosh, Joya Ghosh has something against you also.
Yes. I have seen that. I have seen that.
If the marriage has broken beyond repair, then you are gone.
But nowadays, my lord, this thing happens within the footfall. If your lord
At the drop of a hat.
Drop of a hat.
Anyway, I am not a big believer personally. I mean, sitting in court, I should not say this, but I am not a big believer in interference of court in personal matters, personal laws of any type. Apart from succession, there may be some law involved. This coaxing parties to go back together and live together and go to Puri and reconcile between themselves. This seems very ridiculous.
Each and every matter comes to us, we first try to get.
We always do that. But there's a limit to everything. I mean, these are personal matters, notions, perceptions of parties themselves. And custody matters are worse. Seeing a child being dragged after an order of court, it's ridiculous. I mean, why should courts interfere? The interference of courts should be least. But our law does not permit that. Our law has to have legal sanction at every point of time from courts, apart from the marriage itself. Right. Once you marry, you are in the mercy of the court. So, on what point are you citing this judgment?
But the affidavit of evidence and the application which he has filed, there is no corroborative evidence. My lord, does not disclose any cruelty.
Now, which portion of this judgment, any particular paragraph?
I'm showing that, my lord. Para 40, 70 to 72 and 79 onwards. Madras High Court. Para 40, 70 to 72 and 79 onwards. Shamor Ghosh and Jaya Ghosh judgment is also referred here.
Yes, we have seen that. We have
Page
seen that.
77.
We have seen that. That is also referred to you. This is Roman 14 goes against you just before para 79. That is quoted from Shamor Ghosh.
Yes.
At best, that may or may not go against you, but Mr. Trivedi may argue this. Yes. This is more on the facts of the case, this judgment.
Similar fact, my lord. Similar
No,
fact.
here she was pregnant and she for that reason.
For that
She was sent out. So you'll hear Mr. Yes, Mr. Tiwari.
Because today is 3:30, I suppose, my lord, I'll not be in a position to conclude it. But, my lord, I shall start, my lord. Start, my lord, where what has
We
followed.
don't have any qualms with 3:30. You can continue. You can conclude arguments. Regarding the criminal complaints, you have nothing to say.
No, my lord.
Don't even start arguing on.
No, my lord. Criminal complaints, my lord. What is the law which has been laid down by the Honorable Supreme Court, starting from my lord Justice Dalvil Bhandari's three
What has
judges
been
bench,
laid down?
and after that continuing till recent, my lord, it has been said the Honorable Supreme Court has gone to that extent that even in the written statement, if allegations have been made, that also tantamounts to cruelty.
Unfounded.
My lord,
Unfounded, baseless.
My lord, unfounded.
3 criminal cases have been lodged here. Court says that by itself amounts to cruelty. That is page 77.
My lord, I'll come to those judgments, my lord, where it has
Patently contrary to
one
law.
judgment is there that even in the written statement, my lord,
allegation is made which is unfounded.
I argued this particular point, my lord, and the honorable coordinate bench of this honorable court has come to this finding, relying on the judgment of the Supreme Court, which says that in the written statement, and which was in the written.
That is settled, Mr. Trivedi. The written statement, if allegations are made which are unfounded, and in 99% cases, those are of illicit relationship.
My lord,
must be this case also.
My lord, I'm not on that. If any
written statement also states something which is unfounded, baseless, and so cruel that it could cut off the relationship between the parties, definitely.
Well, that is one branch.
Lodging one 498A and a domestic violence case.
Not one 498A, lordship. It has been the entire family has been dragged into that.
May have been some basis.
My lord, it may have some basis, and the timing of that case. My lord,
trial court does not find in your case, even Mr. Trivedi, that those were baseless without any foundation.
Well,
court says itself by filing it amounts to cruelty.
I am championing for that cause only, because the Honorable Supreme Court also says that. Maybe it's a bad law, my lord. What has fallen from your lordship, my lord, I will not. But my lord, that
Supreme Court cannot say that.
My lord, man proposes, God disposes. My lord, I being I have to argue my case based on whatever has been laid down by the Honorable
Supreme Court. Man has proposed and God has disposed in your favor.
My lord, not here, my lord.
The woman did not
Supreme
get justice. That is his contention.
No, what has fallen, my lord, Honorable Supreme Court. I am not saying that whatever I am trying to impress.
You are quoting from the language of Supreme Court.
My lord, no, I'm not quoting. Yes, my lord, that some portion, because I was also, my lord, astounded in arguing another matrimonial appeal, which when.
But make it very short. You want to prolong it, you can understand.
No,
starting from Justice Dalvir Bhandari.
I will not.
You will be only citing the landmark judgments and only on relevant. Don't repeat judgments on any proposition.
My lord, I will keep it very short. My lord, I will not.
If you cite multiple judgments on one proposition, Mr. Trivedi, at our own choice, we'll be choosing from those judgments. Any one which does not apply, which applies the least to you.
my lord will give me one fearlessness, my lord. I have had vast opportunity of assisting your lordship in matters, my lord. So I know, my lord, what my lord, why I will not make it lengthy. I will be pat on the point.
what about
And
this?
secondly, my lord, as far as the complaints are concerned, my lord,
Yes.
I will be there, my lord, if my lord kindly comes. What I'm starting from that point, what was shown from it. Now, if my lord comes,
Complete with the club or the office?
no, club, I'll come later, the office, where I lost my job. It was
Yes.
a contractual.
Yes, whether you lost the job due to this.
Yes, my lord. Now, my lord, if my lord kindly comes to page
48 and 49.
40.
Yes.
Yeah, my lord, it was a contractual job, so I need not be fired for that job. Person, whoever it is, he may allow me to complete, but it will not be where I had a very fair chance of extension. Any good office would not enter into any such personal issues where the wife is coming on each and every day and lodging complaint. So, my lord, and no reasons granted because they need not grant any reason for
You
extension.
don't get that every day she was complaining. You have
My lord,
only one. You have exhibited one document.
what we wanted to say. Actually, that was not refuted by the lady. The gentle lady went on saying, yes, I lodged a complaint. And what the case is being made out
Should she tell a
by
lie?
my learned friend.
Had lodged a complaint.
My lord, what the case is being made out by my learned friend off the cuff before this honorable court from the bar is that the gentleman was untraceable. But that is not there.
Not off the cuff, it's there in his inner pleadings.
As far as this complaint is concerned, as pleading is
For
concerned,
that we are not.
remember, that is what I'm saying. One. And secondly, when the husband was contesting all these, so now Miller will kindly come to page, I'll rely on page 28. Reference to the letter received from so and so regarding complaints and allegations received from the lady for some time past. That is not on once. It is on for a few occasions. You are hereby directed to explain the facts and details, also stating whether any court case is pending or there is any order of the honorable court in this regard. So, my lord, by that time, the complaint cases were lodged. By 498A was there against me because the date is very significant. That is 15/7/2011. Now, my lord, next page. As directed by the authority, you are hereby informed, being dissatisfied, your contract agreement for the post of assistant engineer, district so-and-so, has not been renewed. Now, Millet, here, if it is a renewable job, they need not give any reasons. But Millet,
how do we connect the two? How do we connect the two? That show cause was given to you in 2011. After 9 years, how could you believe?
No, Millet. It is 15/7/2011. And my lord will say it is 25/8/2011 at the bottom. It is within 1 month. I lost my job. That was the time when it was going to be extended. Timingly very perfect. It cannot be said that it was for any other reason under the sun, but it preponderance of probability says that this is what has happened because the timing was very important. And Milord, lordship will come. Then Milord, as far as the complaint to the club is concerned, if my lord,
yes,
the complaint itself says, Milord, that it was not only that she was looking about the whereabouts. It was so many other things.
No, it is much more than that. Not only whereabouts. That we have seen.
So, my lord, it is to tarnish.
What is the page number again?
My lord, it is page 26, the Bengali version, my lord, and 26A is the English translation.
Yes.
Yeah, my lord. We'll kindly see if I may allowed to read the English translation. I'm coming to the second paragraph of page 26A. My humble request that today I came to my husband's house with my newborn baby, but the house is locked, so I have to go back. I went to the Madhyamgram house as well as that was also locked. I want to notify you and everybody that after my marriage, I was tortured by my husband, including his mother, sisters, and sisters-in-law. On 9th October, I was unable to fulfill the economical desires, so my husband told me to leave the house. His mother can't live with me because of that. From 10th October, he suddenly break all the contacts with me. I am full in anxiety because I know this type of things done before my husband. I am afraid, so I want to notify you, sir. He is this type of intention to do such things, but I am ready to start a new life and my husband and for child's sake. So please help me to restart my family peacefully. Please
You
inform
read the Bengali one
my
because
lord, that
that will be more appropriate. Please read that. Read the Bengali portion. I love to hear your accent. Read it so that my learned brother can follow.
আমি শ্রীমতী কমালিকা মজুমদার আপনাদের my lord, I shall come back.
Paranivasi.
My lord, I shall come back on Tuesday. My lord, I'll be more.
Move on to the next document. No difficult.
My lord, it's 3:30, my lord.
So what?
My lord, let this matter see one more light of one more day. Because my lord, I have to prepare myself with. I'm being very candid before my lord. The 4-5 judgments, which I thought will be to my now I have to come to plan B. The best part about advocacy lordship is I come to the honorable court with plan A. Then what my adversary says, I change to plan B. And what falls from the honorable court is beneficent to come.
In some courts, Mr. Trivedi, you have to have up to plan Z.
My lord, I always plan, but my lord, I am taken by surprise.
ধীরাজ যদি এটা বাংলায় পড়ে যায় তাহলে একটা চান্স আছে যেটা very well. Hard in part for further hearing on. We'll keep it on next Thursday, or we are keeping it on Tuesday. If you reach it, we will take it up. If you are not in difficult.
My lord, will it be my lord's pleasure to keep it on Thursday, my lord? Because my lord, Tuesday, my lord, maybe my lord, I'm running here and there, but Thursday, my lord, I don't keep anything because when matters are before, appeals are before my lord.
Very well. Thursday notification. Very well. Hard in part for further hearing on May 15, 2025.
I mean that.
Come prepared on those judgments as well as this letter.
Because my lordship's mind is loud and clear, which I have understood. And only on those points, I will try to amplify my argument. Nothing more, nothing less.
No, this I was actually reading it erroneously. The dismissal. I thought it was 2020. So because I missed out that because in the photocopy some portion has been deleted. In the signature, we found it's within 1 month. Automatic call. না থাকলে not today, না থাকলে not today. Just not today. আছে?
My lord, 3:30, my lord, nobody will attend, I suppose.
We have to call. দেখি না ছেড়ে দিন আজকে 3:30 আছে ফুট বয়কট করে দিলে কিছুই শুনতে পারবো না বসে একদম মাছি তাড়াতে
19 I am for the
move the matter 19 call who is for the other side. Very well, you take up the matter.
No, 19.
You are for the other side. See his beautiful smile. Not today.
Every day they are taking last 2 occasions they
will record your submission on that. But we'll grant him time. Because he won't be able to, he'll be embarrassed before his senior. Oh, you are for the state?
Yes.
State? No senior business. Start the matter.
My lord, I am not on record.
Are you in the panel of the state?
No, my
Then we'll dismiss for default. You have no locus standi to ask for time. We'll give them a last chance. We'll record that in order. This is the third occasion when none appears for the state at the time of call. Full stop. As a last chance to the state to appear in the matter, comma, let the same stand adjourned for the day. Full stop. It is made clear that in the event the state remains unrepresented on the next occasion when the matter is called on for hearing, comma, appropriate orders will be passed in the absence of the state. Inform your whoever is appearing that we have recorded this.
9 is their appeal, 10 is
Yes,
my
you saw that. That's why you referred to them as state, not appellant or respondent.
10 is court.
Other rules. Other side is there. Both sides are there. Today we won't.
Yes, 3.
You have any difficulty in walking?
No. Wrong setting.
So whatever you say, if you starting piecemeal won't help me, sir, because you are seeing we are disposing of matters.
Yes, very short matter, my lord.
You will be able to. We are confident that you will be brief. So
yes.
If the other side is
5
there,
to 10 minutes.
Oh.
Because suit by the subtenant after challenging the decree. Separate suit.
not order 2101.
No. And it's a clear bar, my lord.
Who is appealing for the other side?
My lord, initially Sopusayi Chatterjee, thereafter Mr. Parthasarathi Roy.
Parthapratim Roy.
Parthapratim Roy. My contention is very brief.
Order sheet ta dekhi. Every day you will call at 3:30 and then say these things. What can be done?
Kindly see, my lord, decree they
But they were
obtained ex parte. And my lord, that ex parte decree without servicing of summon. And when we came to know, when police help was allowed, then judgment letter of my suit, he, my lord, equipped with that or
No,
that.
But he is against an order 9 rule 13 application.
Yes, order 9 rule 13. Order
9 rule 13
but
will leave
where
out.
my lord, suit is not expressive word.
Can you look at that at the order 9?
My lord, High Court, my lord, in the appeal, my lord, obvious.
Not so high. Anyway, it's a short matter in any event.
Yes.
Now, I will record an order since you are appearing. Mr. Poddar appearing for the appellants submits that the appeal is on a very short point. However, since none appears for the respondents, the matter be adjourned for the day. It is made clear that on the next date, if the respondents are unrepresented, appropriate orders may be passed in the absence of the respondents. এরপর যদি করতে চাই করে নিতে হবে সেজন্য আমরা দিনের পর দিন তো বার ডাকছি বলে
Lord, we are for the plaintiff respondent.
other side if the other side is not present.
Waiting for the appeal.
None appears for the appellant or the plaintiff respondent is represented through counsel. Let the matter stand adjourned for the day.
Yes, Lordship.
Lordship, in item
You're appealing. You'll move the matter.
Yes, Lordship,
Order to carry
I'm led by Mr. Mukherjee.
We'll take up the matter.
He is
Mr. Which Mukherjee?
Tanmay Mukherjee.
Tanmay Mukherjee.
Lordship, I am told that he is below. I have called him. Lordship,
Yes.
this matter was heard on the earlier date substantially by your lordships. This is a matter regarding partition in which a decree has been passed, which is under challenge. Lordship we had framed was pleased to note down two issues that
Mr.
ঢোল করেছে ভর্তি নাকি ঢোল তন্ময় আর কি করবে previously there was a remand.
Yes, Lordship, there was a remand, and after the remand, certain additional parties were added as respondents, which were not added in the previous suit. Thereafter, after remand, their written statements were also filed, and thereafter
we have taken down some points, but
yes,
I've forgotten whether these were the grounds of remand or your present ground.
No, the present.
One is preliminary degree without declaring defendant's share.
Yes.
These are your grounds.
Yes.
Second is no specific issue framed on Hibanama.
Yes.
Third is court held that Hibanama description, the description of the property in the Hibanama is regarding a different plot, not the suit property. You say that is wrong.
Yes, that is wrong, and which has been specifically contended by us in our written statement also. But an issue to that effect was not framed by the honorable trial court.
So 2 and 3 are related regarding this description and Hibanama. No issue being framed.
So, Lordship, in relation to that, one more suit property should have been added in the schedule of the property, but that was also not added.
You are the defendants.
Yes, we are defendant number 1 to 7 in the and the appellant.
And another point was no relief of rectification of Hibanama was
yes, because since
to include those
Yes, yes. Lordship, on the earlier date, what has happened is that the paper book, the translated copy of the paper book was not tallying with the.
Right. Yes, you have resolved that issue.
Yes, we have a copy of the, actually, Lordship, the stay application which has already been dismissed contains the copy of the original plaint and the written statement. There, Lordship, we have compared, and here also we have compared. So it is, we can
You
move
can
that.
add the- but does that tally with their paper book? We don't know. Oh, you have copied, you have tallied with the paper books themselves.
Yes, yes, paper.
So those tally more or less.
No, Lordship, there are mistakes. So I would be praying that if your Lordship can rely, or we have a copy of the of a written statement and plaint. We have a copy of the Xerox copy.
Those are the only documents which are not telling. Plain and written statement.
Yes, Lordship, more or less, because we would be relying on those. We would be
Those are
relying.
not there in the paper book.
No, those are there, but it is not
Errors.
errors. There are errors.
In those, or errors in other things also, like evidence and all.
No, Lordship, only on those two parts.
Plain and written statement, do you have extra copies? You have to have 3 copies, 2 for us and 1 for. And 1 for the little boy who lives down the lane.
Lordship, the plaint and the written statement had been annexed in the stay application. And
Do you have a copy of the stay application? He must be prepared with the paper books only. Just check up whether you have a copy of the stay application. We have our copies of the stay. So we'll rely on that. Provided they also have it today. Stay application টা এখানে কি আছে নাকি? মেমোটা আছে, থাকবে, তাই দেখে নিচ্ছি, থাকবে। ছেড়ে দিন, দেখে আছে। না, এই ফাইলটা এখানে একটা বলছে এরোনিয়াস হতে পারে। ফাইলটা মেন ফাইলটা ঠিক না? স্টে অ্যাপ্লিকেশন। You have copies? Very well. We can proceed then.
Lordship, may I kindly come to page number, এটা কত? 7 of the, না, এটা তো আমাদের তো stay application না?
You rely on the stay application or?
Lordship, may kindly come to page number 24.
24
of the stay application.
Yes.
Lordship, may kindly see paragraph number 5. Paragraph number 5, I'm reading from the middle portion, Lordship.
Right.
Where they have specifically made an averment that the dag number which they have mentioned in the Hibanama is wrong, which is Kintu Ukto number Dolil Khanir Topshil 570. Lordship has got it.
Yes, we are reading it.
574/1103 number dage উল্লেখিত না হইয়া কি ভ্রমাত্মক
erroneously.
হ্যাঁ, ভ্রমাত্মক।
You are Mr. Pathak. You are reading Bengali very well. Yes, read on.
574/874 number দাগ লিখিত হইয়াছে। হ্যাঁ, this is the specific government which we have controverted at page number, Lordship, 37, 30,
34. 34 is the answer to para 5.
34, Lordship.
Has to be 34, yes.
বাদীর আর্জির 5 নম্বর দফার উক্তি মিথ্যা হইতেছে, ইহা মিথ্যা যে গফুর মিয়া নালিশি সম্পত্তির মধ্যে হাফ অংশ ভোগ দখল করিতে থাকা কালে সে নালিশি সম্পত্তির মধ্যে হাফ অংশ বাদীগণকে 21/1/81 তারিখ সম্পাদিত ও 22/1/81 তারিখে রেজিস্ট্রিকৃত 692 দলিল মূলে হস্তান্তর করত দখলে প্রতিষ্ঠিত করে, ইহা মিথ্যা যে বাদীগণ একত্রে নালিশি সম্পত্তির মধ্যে হাফ অংশ এক এজমালিতে সত্ত্বে দখল রইয়াছে, ইহাও ভিত্তিহীন যে উক্ত দলিলে তফসিল 574/1103 দাগ উল্লেখিত না হইয়া 574/874 দাগ হইয়াছে। ইহা
So
মিথ্যা
here you have dealt with it.
here
Only the word bhomattok bhavi you have left out, but you have dealt with it.
dealt with it
You say that it's not a fact that this
has been
dark number was recorded
erroneously.
Yes.
So, Lordship, I am saying that this on the basis of their averment and my specific denial to of that fact, an issue
ought to have been framed.
And consequently, DAG number 574/870 572/874 ought to have been included in the schedule of the
So court proceeded on. They say that this instead of 574/1103, 574/874 has been written. Court proceeded on the basis of that. It should have been 1103.
Yes. Lordship, may kindly come to page number 43. They have the learned court has recorded our submissions also to that effect, but no issue, no findings to that effect has been made.
How to come to the finding that this is a true fact?
This is a true fact that no,
This is your Hibanama argument.
Yes.
That this issue was not framed.
No. This issue
And
was
no relief of all three issues on this. No relief of rectification of Hibanama was ever claimed. One. Secondly, no specific issue framed on Hibanama. Thirdly, court held that Hibanama description of property regarding different plot is wrong without any basis.
Without any basis. And Lordship, so the 874 ought to have been included in the schedule of property, and which we have specifically
874 instead of 1103.
Lordship, 1103, if
That
they
is
are
their
that is they are saying that it should have been 1103. So if they have included 1103, they are contending that they have received 1103 under that Hibanama, but they have said but it has been erroneously written as 874.
1103 is otherwise involved.
It is otherwise involved. Lordship, the specific submissions that had been made is that
internal 4
internal page number 4 of the judgment. Before that, Lordship, our submissions start from page number 3 itself. Defendant number 1 to 7 have appeared. Lordship has got it.
Yes.
Defendant number 1 to 7 has appeared. Then the next page, Lordship, page number 4. The specific points from the middle, Lordship, they have denied the deed number 692 executed on 21st of January 1981 and registered on 22nd of January 1981 by Ghafoor Mia in favor of the plaintiff. They have also denied that Ghafoor Mia transferred his property in plot number 574/1103 and gave possession of the same to them. Ghafoor Mia had no property in plot number 574/874. The suit property was owned by Chameli Beva, and Chameli Beva sold out the landed property in plot number 574/874 in favor of Masiruddin, Suleiman, Masimuddin, and Afijuddin, and their names were have been recorded in RSROR. In fact, plot number 574/872 and 574/874 are included in RS Khatiyan number 256, and the said plots has not been brought in the hodgepodge of the plaintiff, in the hodgepodge by the plaintiff. So the suit is not maintainable. Qayyum Mia and Idris Mia sold out the same by registered deed bearing. So, Lordship, there has been a specific recording to that effect, but no specific issue to that end has been framed by the Honorable Court. And Lordship, I'm relying on certain judgments that in partition decree, the shares of all the plaintiffs and the defendants ought to be mentioned. Lordship, the judgments.
Judgment Kuruddin. Give the reference for the learner.
Yes, Lordship, I think I have a copy also. 2009, volume 9, Supreme Court cases, page number 689. Look at your extra copy.
This is on what proportion? All the joint properties have to be brought
No,
to
Lordship,
Rajput.
primarily the suit is based that within what time, it is basically whether a Section 5 application would be applicable in case of when a preliminary decree has been passed by a court, within how much time an application for drawing up a final decree has to be made. But Lordship, I am relying on, while discussing that matter, courts has made certain observation which are relevant. Lordship, Lordship, may kindly have regard to paragraph number 18.
Yes, 18.
Yes, if I may place the same. The following principles emerge from the above discussion regarding partition suit. In regard to estates, access to payment of revenue to the government, agricultural land, the court is required to pass only one decree declaring rights of several parties interested in the suit property with a direction to the collector or his subordinate to effect actual partition or separation in accordance with the declaration made by the court in regard to the shares of various parties and deliver the respective portions to them in accordance with Section 54 of the code. Such entrustment to the collector under law was for two reasons. First is that revenue authorities are more conversant with the matters relating to agricultural land. Second is to safeguard the interest of the government in regard to revenue. The second reason, which was very important in the 19th century and earlier 20th century, when the code was made, has now virtually lost its relevance, as revenue from agricultural lands is negligible.
These are irrelevant for our purpose.
Lordship, the finding is that first the court will pass a preliminary decree declaring the shares of all the parties. On the basis of that preliminary decree, the pleader commissioner will go to the suit property.
That is the provision of the Code of Civil Procedure.
Yes, Lordship.
So how is that relevant here? You say that a relevant issue has not been framed.
So
how is this judgment relevant at all?
Lordship, I am saying that since these are the observations of the court.
What is the ratio laid down here, which you are relying on?
Lordship, these are
the procedure how a partition should proceed. So where is the difficulty in that?
So Lordship, I am.
Your preliminary decree has been passed. Why this judgment is utterly irrelevant?
So Lordship,
the point is that
our share has not been declared.
Both sides, there is a disputed issue. No issue was framed on that. That is your
and
point.
our share has not been declared. The share of the defendants in the partition in the preliminary decree has not been.
How is this judgment relevant for that?
Lordship, this judgment is saying that the shares of all the parties to a partition suit has to be.
Was that relevant sentence? All the parties must be declared.
Lordship, may kindly come to internal page number 697.
We are there.
Page number 2.
Yes.
Where the division is by meets and bound, where the division by meets and bound can be made without further inquiry, court will pass a preliminary decree declaring the rights of the parties interested in the property and give further directions as may be required to effect the division. In such cases, normally a commissioner is appointed, usually an engineer, draftsman, architect, or lawyer, to physically examine the property to be divided and suggest the manner of division. The court then hears the parties on report and passes a final decree.
Is the court just quotes whatever is there in this Code of Civil Procedure? This is not a judgment on your point at all. There is only one defendant.
No, there are several defendants.
I am trying to say that inter se the defendants, their respective shares ought to have been declared.
No, the shares of the defendants have not been mentioned at all.
Plaintiff's share has been mentioned.
Has been mentioned. Plaintiff's share has been mentioned.
Let us see the judgment,
Yes,
present impugned judgment on that portion. What is the decree? Should be decreed ex parte, plaintiffs.
The suit, page number 113.
Yes.
That the suit be and the same is decreed on part on contest against defendant number 127 and ex parte against the rest defendants in the preliminary form without any order as to cause. Plaintiff number 1 ka, 1 kha, 1 ga have 0.59 decimal of land each in plot number 574/872 and 0.109 decimal of land each in plot 574/1103, and plaintiff number 2 to 3 have 0.161 decimal of land each in plot number in plot number 574/872 and 0.328 decimal of land each in plot number 574 oblique. It should have been Lordship 1103. It has been wrongly written.
Very.
So Lordship, here and then the court goes on to record that the plaintiffs do get a preliminary decree for partition against the defendant in respect of plot number 574/872 and 574/1103. Both parties are directed to make partition of the suit property amicably within 3 months from date, failing which the plaintiffs will be at liberty to pray before the court as per law. Lordship, this is the decree.
Your portion has not been your shares must be the rest of the property.
Lordship,
Whatever it means.
the defendants, there are several defendants, so
Their respective shares should have been. Very well. First point, and what other judgment you are citing?
Lordship, this
judgment is not relevant. We are taking this since you are citing.
Paragraph number 5 बोलेंगे किंतु paragraph number 5 तो की हमें जानेंगे कि paragraph number 5 এটা কি ये तो by setting aside of abatement যেন order 22 rule 9 enables the court কি এটা করবে নাকি that is setting aside Lordship, that is the only judgment which I'm.
So let us hear them. Yes. No issue framed on Hivanama. Specific point taken that it was erroneous. But court all the same passed a decree as if the plaintiff case was sacrosanct. Without any proof, without any basis that there was an error in the Hivanama. No prayer for rectification of Hivanama. This is the first question. Second is preliminary decree without declaring their share. Why shouldn't you remand it on these?
My lord, it has been specifically stated out here. Even in the judgment also it has been dealt with.
Was that
the
portion?
property? Yes, Raj. The property initially, the original owner, that is in the CS record.
Yes.
One is Chameli Beva. She was the owner of the suit property. And along with that, Your Lordship, the other property, which was the subject matter of the deed, the gift deed, that's been executed by Gafur Mia in favor of his sons, the respondents out here, being the plaintiff out there. It has been wrongly stated in the state and place of that plot number 574/874. It has been wrongly stated in the state and place of 574/1103 for the reason that Chameli Beva, during her lifetime, she had transferred this property, the plot number 574/874. She, during her lifetime, she had transferred the property in favor of Nasiruddin, Sheikh Suleiman, Sheikh Moshiruddin, and Aminuddin Sheikh.
Therefore, she did not have title in the property.
She had no title over the property.
She did not have title in the property. The gift deed becomes vitiated. That becomes
Gift deed, Your Lordship,
invalid.
what has happened, my lord?
How can the court say instead of that another property was intended to be gifted? How can you say that?
My lord, the property that was gifted, they were in possession.
How can the court rectify the deed?
Yes, Lordship, that is there, Your Lordship. The father.
I transferred to you X property. Court may very well hold that I did not have any title to X property. Therefore, the gift deed is invalid or no title passed. How can the court say no? I did not have title in X. Therefore, in the gift deed X should be read as Y. How can that be done? I never transferred Y. Chameli never transferred the other property. How can the court rectify the deed without a formal prayer for rectification?
That is there, Your Lordship. That is there. That is one thing. But my lord, the learned court below has dealt with, Your Lordship, with regard to the gift amongst the Mohammedan. That is at page 41 itself of the application.
How did the court go about this? I mean, saying that no, there was an error in the Hivanama.
Error, definitely the plot number has been wrongly written. That is there. That no one can.
Plot number has been not wrongly written. The plot number has been written, it's a registered gift deed.
Yes.
We have to go by that.
Yes, yes, Your Lordship.
So if the lady did not have title in the plot, then the gift deed is vitiated. It is bad in law. How can you say she intended to give something else? How can you interpolate that?
Not she, Your Lordship. The
He or she,
original,
whatever.
my lord, original owner, she had parted with possession in respect of the same property.
You don't
in
understand
favor.
this.
Yes, I could.
A gift deed is executed in favor in respect
the
of X
father-
property.
by the father.
Court says X property, donor did not have any right. Very well, gift deed goes. How can the court say no? X should be read as Y?
That is that.
Beyond all logic. And how did the court hold it? Let us see that portion. Show us that portion. Internal page 11, court starts with exhibit 1, original gift deed. Hibanama. This was Gafur's Hibanama.
Yes, Lordship. My lord, issue 227 at internet page, it starts from 10. The issues are taken up together as they are correlated to each other.
Come to page 11. Page 11 deals with the exhibit 1. Second paragraph. Why waste time on issues? একদম শেষের দিকে এখানে শুরু করেছে. A plaintiff has stated in the plaintiff was not owned by Gafur or executor. Not effective in respect of plot number 1103. $874 by $874 Gafur owner ছিল না বুঝলাম. Hmm.
574 of 1 month.
Blood Gopur was owning plot number 474 by 11 by 03 along with the defendants. This is one of the suit property.
কোর্ট তো সেটা বলেনি যে গিফটটা ইয়ে কোর্ট এটাই বললো এক্সিবিট 1 is not effective in respect of plot number 574 by 1103 আবার সেটা করতে হবে. Third, সেটা প্রিন্টেড বললো. প্রিন্টেড বলি inadvertently plot 1103 574 টা কমন ছেড়ে দিচ্ছে. 1103 was not mentioned, তার বদলে 874 was mentioned. এবং তারপর বললো 874 ভুল করে মেনশন করেছে না, গিফট ডিডে লেখা আছে 874, বলছে সেটা ভুল করে লিখেছে, it should have been 1103. Inadvertently plot number 1103 was not mentioned, wrongly written as 874. এবং 874 he had no title. Understood? যদি he had no title তাহলে 574 or 874 ট্রান্সফার করতে পারে না, গিফট ডিডটা ব্যাক. কোর্ট এবার বললো exhibit 1 is not effective in respect of 574 1103. এটা তো nobody's case that it is effective. Court has not held anywhere that the gift deed was in respect of 574 by 1103.
No, Lordship.
It was their case that 574, we are skipping the 574, it's common. That 870 by 874 was written, but it was erroneous, should have been 1103.
Yes.
Court finds that 874 Gafur had no right, no title. So therefore that gift deed cannot go. I mean that is vitiated. But court does not say that instead of that it was 1103. Court does not say that.
No, Lordship may kindly come to internal page number 13.
13.
13, internal page number 13.
Yes.
Considering the facts and circumstances of the case and on perusal of the evidence of both oral and documentary, I find suit property has not been made partition earlier and above
That is
mentioned
page number. Yes. Sorry. Continue, please. Consider
mentioned parties
Yes.
are in possession over the suit property in Esmal, and no other property of the parties are left to bring in the hodgepodge of the suit, and there is no interested person in respect of the suit property. I hold that the plaintiffs has unity of title and possession in the suit property with the defendants, and as per request of the plaintiff and request of the plaintiffs, the defendants have denied to partition the same. So Lordship,
property did not include by 874.
No.
Suit property, sorry,
No.
Lordship.
Suit property did not include 574 by 874.
No.
No, Lordship, 874, they are saying that it is erroneous.
Property did not include 874, but included by 1103.
1103.
Oh.
Lordship.
So you say that then 874 is right.
Huh. Yes, the very next page. The very next page, Lordship. The plaintiffs.
Actually, 874 যদি টাইটেল না থাকে তাহলে 874 ডিক্লেয়ার করবে না 11 সুট প্রপার সুটটা ফাইল করছি বাই 874 নিয়ে নয় 1103 এবং বলছি গিফট ডিডটাকে কনস্ট্রাক্ট করো বাই ভার্চু অফ দিস এই ডিক্লারেশন অফ টাইটেল কোর্ট অটোমেটিক্যালি ধরে নিল যে ওটা 1103 so you mean to say that by this declaration court automatically substitutes that 1103 instead of
Yes, Lordship, if that was their case, first of all, an issue should have been framed. That is one thing apart. But they have not even prayed for rectification or anything even prior to this.
We're not on rectification. Shows that the court premised its finding on their averment that instead of 874 it should have been 1103. Court does not find that. Rather, page 11, internal page 11, last sentence, court says plaintiff has stated in the plaint that inadvertently plot numbers are their statement.
Their statement.
Then exhibit 1 is not effective in respect of plot number 574 by 1103. Probably the court meant by 874. Whatever, then court holds that it's not court does not hold that that 874 should be read as 1103.
But Lordship, a decree has been passed. Decree, Lordship, may kindly come to page number 14. Decree has been passed. Plaintiffs do get a preliminary decree for partition against the defendant in respect of share in plot number 574/872, and
this share is calculated on the premise of that gift deed. If
they have acquired through gift deed, Lordship.
If that gift deed was not there, they wouldn't otherwise have any title in 1103 by 1103.
Lordship, Lordship, but they are claiming through that gift deed. They are claiming
court, there is no reflection that the court relied on their gift deed. They can claim share in 1103, 872 by 574 by 1103 in two ways. They may have some portion through a gift deed and rest through otherwise inheritance or otherwise. We are asking you whether their claim to 1103, 574 by 1103 was only through the gift deed or also independently they had right regarding. If they had independent right, it is not reflected that court relies on the gift deed at all. Independently, they might have been their share might have been declared. Court does not rely on the basis findings on the gift deed. Rather, court says that exhibit 1 is not effective in respect of plot number 574 by 1103 and proceeds on such premise.
So, to that,
court does not say anywhere, and court proceeds on that premise. See page 12, internal page 12. After holding that the exhibit 1 is ineffective, court says narrates how Gafur Mia got it. Then says so Sheikh Gafur had 50% share in respect of plot 574 by 1103. So Gafur had that share irrespective of the gift deed. Court does not rely on the gift deed. Court says that is ineffective. Gafur independently had 50% share in 1103 and plaintiff numbers 1, 2 and 3 each have 0.328 decimal in plot number 574 by 1103.
Is the basis of that finding is
court does not rely on that gift deed anywhere. Court does not do that rectification. Show us one place where it has been relied, where the gift deed has been relied on. Rather, court says it is ineffective in respect of 574 by 1103. that even if the issue was framed,
Yes.
that issue was never decided in their favor. So you cannot be aggrieved on that. Court never finds that
On the basis of the gift.
on the basis of gift deed. Not a single reflection. Rather, court says it is
Otherwise.
ineffective. Yes, and
Okay.
says that Sheikh Ghafoor had 50% share. The narrative is given how he had that.
How it-
Exhibit 5 is relied on. Other things are relied on. Let us see this. No, another sentence is there. I'm sorry. Usman Ali, Muhammad Nurul Huda, and Muhammad Ilyas obtained 1/3
No,
as
sure.
per. Yes, yes. No, the next page 12, the third sentence.
Page 12.
Page 12, the third sentence. Usman Ali, starting from there.
Usman Ali, Muhammad Nurul Huda, and Muhammad
They were
Ilyas.
the donies in Exhibit 1.
Exhibit 1, that is deed number.
They are the defendants.
No, defendants are Lordship Muhammad.
Nurul Huda is there. Ilyas, Nurul Huda, Usman Ali.
Hello.
এইখানটা একটা বললো যে Usman Ali, Muhammad Nurul Huda, Ilyas obtained 1/3 share of such and such in plot number 574 by 872. এটাও তো ভুল বলছে। Exhibit 1 তো 872 নয়। 874।
এই তো কি নাম হবে?
এটা হচ্ছে ওরা plaintiffs.
হ্যাঁ, ওরা তো
They are the
plaintiff।
plaintiffs. না না এইখান থেকে
Exhibit
দেখা
1 বলছে
এইখান থেকে
গফুর মিয়া in favor of Usman Ali, হ্যাঁ have one for
যে
ও
50
ওই
শতাংশ
গিফটটা অনেক
বাড়ি
কিছু
বলে
কভার করেছে। এটা শুধু ওটা না,
মানে
বলছে ওতে
respect of the view
one of
they have
executive
claimed
gofur
the
in respect of
property.
Usman Ali have such and such in plot number এত। এইটা
1 থেকে 7 নম্বর 1 থেকে 3 নম্বর বাদীগণ নিম্ন তফসিল
হ্যাঁ,
বর্ণিত
হ্যাঁ।
সম্পত্তির উক্ত
574
রূপে
by
দিবানামা
872 আসছে।
দলিল রূপে
সেটা বললো
পঞ্চাশ
যে সুদ প্রপার্টিতে 574 by 1103 ও মেনশন করবে।
উহাতে স্বাধীন ও উত্তম সত্য। এটা বলছে যে
এই দেখুন প্লট নাম্বার 574 by 872 has not been changed by the plaintiff. ওরা বলছে গিফট ডিডের বলে by 103 তে 1103 তে আসছে। ওরা এটা বললো।
এটা দেখা যাচ্ছে
কিন্তু কোর্ট সেটা বললো যে এক্সিবিট 1 is not effective in respect of plot number 574. কোর্ট সেটা অ্যাকসেপ্ট করলো। Exhibit not by virtue of Exhibit 1, several properties were gifted.
Yes.
One of them was 574 by 872, on the basis of which you will find at page 11, middle of the second paragraph, the starting sentence of the 574 by 872 was also given. 1.94 acres out of that. So that there is no quarrel on that.
So plaintiff number 1 ka
And also 2.09 acres in 574 by 874. But in schedule of plaint, 574 by 872 and 574 by 1103 has been mentioned.
has been
Court
mentioned.
says that. Court proceeds on that premise, and next sentence court says 574 by 874 not claimed by the plaintiffs. Very well up to that. So 574 they say was erroneously mentioned. Even if it was not erroneously mentioned, since Ghafoor did not have any title in 874, plaintiffs are also not claiming that. So 874 is not a part of the suit property at all. Are you claiming title in 874 by 874?
Lordship, in 874 I have properties. In
You have a property.
Yes, because I have specifically stated in my WS. My WS.
But gift deed has not been given effect to by the court. Court says 574, 874 was not owned by Ghafoor Mia, the executant of the deed. And Exhibit 1 is not effective in respect of plot number 574 by 110. So this was decided in your favor. What the court did not do was not declare your shares.
Not declare my share. So, Lordship, my shares have been declared Narishi in page number 35 of the.
If you find, if you see the court's finding, court is absolutely justified otherwise. Please come to page 11, internal page 11 of that, your page 50. Come to the last sentence. Just before the last sentence, court says plaintiff has stated in the plaint that inadvertently plot 574 by 1103 not mentioned, wrongly written as such and such. And plot number 574 by 874 was not owned by Ghafoor Mia, executant of the deed. Up to this, it's all right. Then court says Exhibit 1 is not effective in respect of plot number 574 by 1103. As Gofur Mia had 1/4 share, so he had right to transfer such and such in plot number 574 by 872, which is the other plot covered by Exhibit 1.
Yes.
And it proceeds to say Osman, Nurul, and Ilyas obtain 1/3 share of such and such in 574 by 872 as per Exhibit 1. So Exhibit 1 is restricted to 874. This 574 by 872. So that Exhibit 1 ends there. Then it proceeds to say Osman, Nurul, such and such, 872. Then Exhibit 5, and it's discussed Exhibit 5, that is RS ROR in the name of Gofur Mia in respect of 8 anna's share of the landed property. Now 574 by 1103. So Exhibit 5, on the basis of Exhibit 5, 1103 is decided upon. Total area in plot number 1103 is such and such. Gofur at 50, and it proceeds to calculate. And again, it's repeated after a few sentences. 3 sons of Gofur Mia have obtained the landed property in plot number 574 by 872 through Exhibit 1, and landed property in plot number 574 by 1103 as per Exhibit 5 by inheritance. So that issue is not decided. It's not said that 874 gift deed, it says only deals with 8 by 872 and proceeds on that premise. 1103 independently from Exhibit 5 and other documents, it has been decided. So there is no fault in this. Yes, Mr. Dhol, you want to say something?
My lord, actually, my lord, in this matter, he is led by.
Yes, but we don't find any irregularity up to
One
this.
thing, my lord, though I am not, my lord, very much acquainted with this, my lord, after handing
Yes,
over.
yes.
My
For
lord,
this.
from the even, my lord, the plaint, my lord, kindly sees the plaint at page 8 of the.
So you tell us your point, then we'll look into it.
Page 8 top. My lord, here, my lord, it is stated that বর্তমান এলার জরিপে নালিশি সম্পত্তির মধ্যে 50 বাই 100 অংশ সম্পত্তি বাদীগণ নামে চূড়ান্তভাবে প্রকাশিত হইয়াছে। What is the basis of this recording in the record of rights? Just before that, নিম্ন তফসিল বর্ণিত সম্পত্তিতে উক্ত হিবানামা দলিল মূলে 50 বাই 100 অংশ। So, my lord, kindly, if it is taken into account that why it is 50 by 100, why this portion has been taken, is that due to that hibanama. It is not that, my lord, that he independently, otherwise than the hibanama, owns that thing. It is on the basis of the hibanama he is claiming, and that is, my lord, what has been given to him. My lord, 50%, my lord, will find from the also from the, my lord.
But it says that Exhibit 5, that is the RSROR in the name of Gofur Mia.
That is recorded in terms of the hibanama.
No. There is
My
no
lord,
reflection of that.
There is their averment in the plaint itself. My lord, kindly see page 25, my lord, the plaint, paragraph page, internal page 8.
Yes. Yes.
Lord, that is উক্ত 578/878 নম্বর দাগের 2.9 একরের সম্পত্তি বিগত আরএস জরিপে তাদের নামে সূত্র রেকর্ড হয়, উহা পৃথকভাবে ভোগ দখল করিতেছে না। 1 থেকে 3 নম্বর বাদীগণ নিম্ন তফসিল বর্ণিত সম্পত্তিতে উক্ত হেবানামা দলিল মূলে 50 বাই 100% সম্পত্তি প্রাপ্ত হইয়া উহা স্বাধীন এবং উত্তম সপ্তরূপে অর্জন করিয়া আশিরুদ্দিন উক্ত 4 পুত্র সহিত এজমালিতে ভোগ দখল করতে থাকে। বর্তমান এলার জরিপে নালিশি সম্পত্তির 50 বাই 100 সম্পত্তি বাদীগণের নামে শুদ্ধভাবে রেকর্ড হয়েছে। This recording is based on the hibanama. It is not an independent recording.
No. But in the previous paragraph, please come to page 24, paragraph 5. After that, that Bhomattok Bhave sentence, which Mr. Pathak read out. After that, কিন্তু প্রকৃতপক্ষে গফুর মিয়ার নালিশি 594 by 1103 নম্বর দাগের অর্ধেকাংশ সম্পত্তি 1 থেকে 3 নম্বর বাদীকে ও উক্ত দলিল মূলে প্রদান করেছে। No.
Everything has based on this on the hibanama.
No, but here also they admit that 50%, Gofur Mia had only 50%.
Yes.
In that 1103, Gofur Miaর নালিশি 1103 নম্বর দাগের অর্ধেকাংশ সম্পত্তি 1 থেকে 3 নম্বর বাদিকে উক্ত দলিল মূলে প্রদান করত। So their case is that 874 was a wrong recording. Gafur Mia had no title in 874. Gafur Mia had 50% in 1103, which by that gift deed he has transferred to this 123. But court does not proceed on that. Court says that exhibit 1 is not effective in respect of plot number 574. Court independently says, in the plaint also they say Gafur Mia in the first place had 50% share in 1103. Gafur Mia had 50%, which he had transferred to 123 by virtue of the exhibit 1. Court proceeds on the premise that so Gafur Mia had 50% share in respect of 1103. Page 12, internal page 12.
Yes.
Court goes on to say that Osman and etc., those three people, they had only, by virtue of exhibit 1, they got only the right of Gafur Mia in respect of 872. Then court moves on to exhibit 5, says Gafur Mia had 50% in that 1103. Then proceeds to divide the property. Then let us see. Gafur Mia and Asaruddin Mia inherited the landed property left by Gazi Mia 50% each. That is the plain case that initially Gafur Mia had. They say that by their gift deed, that was given entirely that 50% to them.
Yes.
Court does not proceed on. Court says Gafur had 50%. Legal heirs of Gafur Mia obtained 50% of the landed property left by him, and legal heirs of Asiruddin 50%. Court proceeds on inheritance, not the gift deed.
My lord, what happened, my lord, if that is not taken into account, my lord, this 574.
Are those three people the sons of Gafur?
Yes.
Then by inheritance they have got.
That's why you have to understand why the deed is.
The deed was necessary kind of
সবাই গোপুরের
By
ছেলে।
way of inheritance,
যারা plaintiff
Clearly.
গাজী।
একদম ঠিক, এটি।
এই ইস্যুটা ছিল
Right. By inheritance they get 50% of Gafur. Clear finding.
My lord, can I, my lord, come back?
You'll have to come back tomorrow because it's 4:30.
Sorry, my lord. My lord,
We are clarifying you. We are clarifying. Tomorrow we cannot come back.
No. That is the my lord.
Tuesday come back. Tuesday is the next working day. You will get some time to prepare. Now, we are of the opinion that court has correctly proceeded on the premise. In the plaint case also, Gafur Mia's 50% in 1103 is not disputed by anyone. They say that 50% was given by virtue of the gift deed to them. Court says no, exhibit 1 is ineffective in respect of 1103 and 874 Gafur did not have any title. So exhibit 1 for all practical purposes goes. Now court relies on exhibit 5 and other documents and says 50% Gafur at 50%. By inheritance it comes to these people and then declares the share on that premise.
My lord, that I will
No difficulty on that. Hibanama, those issues, that issue. Only your share was not declared, we'll look into that. We'll look into that. Heard in part for further hearing on 13th, May 13, 2020.
Obliged to lodge.
Thank you.